Welcome to Looking at Legal Stuff. Today we have 13 hearings, including 5 previously missing new hearings and a new update at the end, with the same felon mother who owes her 2 different baby daddies over $23,000 in child support arrears. The judge demands an explanation after she recently sold her home and profited over $37,000, but chose not to pay a dime of that money towards her $23,000 in arrears. In today's new update, Mom is still in jail and she is not happy. The doctors have declared her incompetent and she is pissed. She thinks that everyone, from the competency evaluators to her own lawyer, are all a bunch of morons who don't know how to do their jobs. What does the judge think of her latest rant? Let's find out.
All right, Mr. Hildebrand, if you can unmute, please. Thank you. We're on the record now in Chelsey Brink versus Devin Hildebrand, case number 1114050. The record should reflect Mr. Hildebrand's present today by Zoom video. Mr. Hildebrand, have been represented in the past in this case. Are you appearing on your own today, or do you have a lawyer that's going to be appearing for you?
I'll be on my own today.
Okay, and this is your motion regarding parenting time, and you're asking the court to change or eliminate Ms. Brink's supervised parenting time. Is that correct?
Yes, sir.
Okay, and I know you put this in writing along with your motion, but can you just make a statement of why you believe that's appropriate at this time?
Well, given the most recent visits over the last couple of months, there has only been probably maybe 2 productive ones out of the last probably dozen. And everything else has been either cut short by me or my wife, whoever is supervising at the time, just for inappropriate contact. For example, there's one time that I put in my motion there where she went off about getting her earring ripped out and then proceeds to tell my daughter that this happened while we were screwing. And my daughter was like, "All right, that's enough, Mom," and hung up the phone. And just the visits are more detrimental to my daughter than they are productive for the relationship between the 2 of them. My daughter, she worries about her mom. She hopes she's okay. But at the same time, it throws her emotionally into a loop of, kind of depression and that stuff if I have to continue doing these. And I don't really want to be held into a court order to subject my daughter to that. If we could put it back to at one point it was as parties agreed, where I wasn't bound into making a weekly visit and setting my daughter into this, setting her up for that. I don't want to completely eliminate contact. If my daughter wants to call her, if Lila wants to call her, I'll let her. I do it even if it's not a scheduled visit day. But I don't want to be forced to continue doing that.
Okay, understood. All right, I had a chance to review the written motion prior to the hearing today. I've heard from Mr. Hildebrand on the record. Ms. Brink did not file anything in response to the motion. The motion was set for hearing at 11:15. It's now 11:23 by my clock, and Ms. Brink has not appeared. I don't see her in the Zoom waiting room to contest the motion. So what I'm going to do, Mr. Hildebrand, for purposes of today's hearing, the court's going to issue a temporary order suspending the parenting time. And then I'm going to set this for a short hearing. I'm going to set it for an hour. I doubt we'll need that much time, but I'll need to take some testimony from you regarding the circumstances. And then how old is it Lila? Is that your child? Yeah. How old is she now?
She's 13.
Okay. And so I'm going to need to, and this may have occurred before, where the referees had an interview with her. And so I'm going to need to do that so that I can talk to her a little bit. She's at an age now where I think she can express what she would like to see happen and get her view on what's been going on. And then once I have those 2 things, then I can make a record, because as you're probably aware through the course of the proceedings, anytime the court changes parenting time or makes permanent adjustments, I have to make findings for the record that it's in the best interests. And I need to have a basis to do that. And between your testimony and what she has to say, and Ms. Brink will have an opportunity to appear for that hearing and tell me what she wants to tell me as well. And then the court can make findings. So, but I think it's appropriate at this point to suspend it based on what you presented to the court so far until we can have that hearing, so that you don't, as you indicated, have to force your child to have those phone calls for the time being until the court can make those permanent findings. Do you have any questions, or do you understand how we're going to go forward?
Yeah, I understand how we're going to go forward on this. I do have some like screen recordings. What is the best way to, would I have to put those on like a USB thumb drive of prior visits, like of my examples? I have some examples on like their videos, but how would I present them to the court? What is the best way to do that?
Yeah, if you can put those on a thumb drive or a flash drive, and then it would be helpful. We'll send out notice of the date of that hearing, but it would be helpful if you can submit that before the hearing so that I can review those.
Yes, sir.
Okay, and then in terms of a schedule of having Lila come in, I can set this at a time that's convenient for her school schedule. Is there a time that would be best, that would make it the least obtrusive for her?
Yeah, she gets out of school around 3. If we could do it sometime between 3 and 5, that would probably work for the both of us.
All right, so if I set it for a 3:30 hearing.
If we could do closer to 4, that'd give me a little bit more time to get from Joburg to Gaylord.
Okay. So the court will set it for 4 o'clock. I don't have the date yet, but I'll set it for later in the afternoon, and then we'll send out the date of that hearing along with the confirmation of the time.
Yes, sir.
And then I'm going to issue a written order today, suspending parenting time. That'll go to the friend of the court, and so you can get a copy of that as well.
Okay.
All right. Any other questions for today?
No, sir.
Okay, thank you. You're free to disconnect at this time.
Alrighty, thank you.
Okay, we're on the record in Brink versus Hildebrandt. This is case number 11145050. The record should reflect that both parties on this file are connected by Zoom. Ms. Kraus, can you tell me where this file is at this morning?
Yes, the plaintiff has a support obligation of $197 and a balance of $8,512.16. The last payment was received in February in the amount of $206.47 from a prior income withholding. There's been no contact from the plaintiff, and the friend of the court does not currently have a confirmed address since March of 2024.
That's not true. I have submitted my address.
Okay, when did you do that, Ms. Brink?
Just 2 weeks ago, probably. And the reason I haven't paid is because I can't get a job. Nowhere seems to be hiring in town, and everything that is hiring is Petoskey, Traverse area, and that's too far of a commute.
Okay, so how do you plan on meeting your support obligation?
I am getting in the middle of getting disability.
Okay, when are you gonna know about that?
August 14th, I believe, is my next hearing date for that.
Okay, what's gonna happen on August 14th?
They have to do an interview.
You what?
They have to do an interview. I'm not sure AT is going to be here to help through it.
You're breaking up. I couldn't hear what you were saying.
From when?
What is going to happen at the August 14th date with your disability?
ACT will be here to walk me through it. I don't know, other than it's an interview.
Okay, when do you think you're gonna have a decision about whether you're gonna qualify for benefits or not?
Hopefully after that day.
Okay, Ms. Kraus, what's the friend of the court's recommendation for today?
Based on the information that she's indicated that she's applying for disability, we do have some medical documentation forms that we could mail out to her and request that she submit and possibly adjourn out 60 days.
Okay, and what about the address issue? Do we have an address for?
I do.
Right here.
Go ahead, Ms. Kraus.
I don't have an address. If she submitted it, we don't have one. The previous address has been marked bad by the post office.
That's not true. My address has not changed in over a year.
Okay,
So-
well, I'm pretty sure.
A post office issue, that's not my fault.
I'm pretty sure Ms. Kraus isn't lying about it, so you need to make sure that you update your address with the friend of the court.
Well, my
And
address hasn't changed. It's still 13th Avenue, Gaylord, Michigan, 49735. That's where I received my mail also.
all right, Ms. Kraus, is that the address that the mail's coming back from?
Yes,
Well, I check my mail every single day. Don't know what to tell you. It's no longer my fault though, or my problem.
All right, well, if that's the address you want us to send stuff to, that's where we're gonna send it. If you don't get it, then it will be your problem. So you're gonna have to figure out that part of it.
Mail. I check the mail every day.
Good. Okay.
So there's no possibility that it's stacked up in the mailbox somewhere. Unlike how the Hildebrands check their mail.
Okay, good. Well, we didn't have any problems then, so that's good. So we'll send the information to that address. I'm gonna give you 30 days to fill out that information for friend of the court and return that. We're gonna set this for another hearing in 30 days. If you fail to do that within that period of time, then the court's gonna proceed with contempt proceedings, which could include incarceration. And Ms. Kraus, would this be a first finding of contempt or a second or subsequent?
I believe it would be first finding.
Okay, so you may be subject to up to 45 days in jail, Ms. Brink, if you don't fill out those papers and return those to friend of the court in the next 30 days, okay?
Talking about. I don't know of any papers. I check my mail every day. The last
Yeah,
paper that I had
we're
to
gonna
get today. I don't
we're gonna
send
send
them in court.
we're going to send them to you at the address you gave us. You'll have 30 days to fill those out and return them to the friend of the court. If you don't, we're gonna proceed with contempt and you may be subject to 45 days.
Get them.
I don't know. That's your problem, not ours. You gave us the address. We're gonna send it to that address. You're
I
not
don't-
getting your,
2 weeks, then I will call the court, have them resend it.
okay. It's gonna be your obligation to make sure that you get that taken care of, okay?
And what kind of stuff is it that I'm supposed to be filling out?
It's gonna be forms related to your application for disability benefits.
How does my disability have any effect on my child support?
Well, you just told me that you plan to meet your child support obligation by receiving disability benefits and using that to pay for it. So that's how it relates.
Okay, and what happens if they deny me again for a disability, which they've already done 4 times? The likelihood of them not.
You're gonna have to find another way to pay for your child support obligation.
Well, there is no other way. I've tried all the ways. This was my last option.
Well, I don't know what to tell you. You're gonna have to find a way.
Don't tell you either, sir. I hope you have a great day.
Okay. All right, so Ms. Kraus, if you can set that hearing for 30 days, please.
Will do.
Mr. Hildebrand, did you have any questions at all?
I don't have any questions, but I also don't understand how she's not paying her child support when she's been to the bars multiple times and she can figure out the gas to get, oh, dang near to Elmira, to my parents' house where she's not welcomed few times this month. And it's just, I just can't fathom how she's doing what she's doing. And that's about it.
Okay, I understand. And like I've indicated, if she fails to either pay support or comply with filling out these forms, then again, the court's going to look at imposing jail time.
Yes, sir.
Go from there. Okay. All right. Thank you. You're free to disconnect at this time.
All righty. Thank you.
All right. Ms. Brink, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in Brink versus Hildebrand, case number 11145050. The record should reflect Ms. Brink is present today by Zoom video. Ms. Krause, can you tell me the status of this file today?
This hearing was adjourned from August 5th to allow the plaintiff to obtain friend of the court forms regarding disability and complete and submit them back before today's hearing. No information has been received regarding her inability to work. The only contact the office has had with the plaintiff is on August 12th when she dropped off a letter requesting to sign off her rights to the child and support to stop. Friend of the court staff did indicate she may need to reach out to probate court to move forward regarding that information. And outside of that, the plaintiff has a support obligation of $197 and a balance of $8,709.16. The last payment was received in February in the amount of $206.47 from a prior income withholding.
Okay, Ms. Brink, why did you not submit those forms as you were ordered to at the last hearing?
I never received them.
Okay.
They were supposed to have been mailed to me.
Did you go in to get the forms?
They were supposed to have been mailed to me. That's why I provided my address at the last court hearing.
Okay. Did you do anything to follow up with that at all?
I mean, it's not really my responsibility when someone doesn't do their job.
Well, it's your responsibility to pay your child support payments, and if you don't
But
pay
that
those
has nothing to do with the disability paperwork.
okay, I'm not going to argue with you. We went
I'm
through
not
this.
arguing.
Yeah, you are, and we went through this at the last hearing. We confirmed your address. We told
Right,
you
so that they could be mailed to me, which they were not.
they were mailed
And I
to
would
you.
like to sign off my rights to my children. And Devin said that he would not fight it. Bill did not fight it. He came and he signed. And when it came time for Devin to sign, he didn't show up. And I have a text message saying that he doesn't want, or that he wouldn't fight me on signing off my rights to Lila or John. So I'm not sure why he didn't sign the paperwork.
So you still are the parent and you still owe the child support.
But I'm requesting the court to terminate my rights to my children. She has a stepmom that can adopt her. I don't want anything to do with her anymore.
Well, there's a process for that, and that process hasn't occurred yet, which means
okay, well, I've asked for that process to be started a year ago. This is the second time I'm bringing it up.
Okay, well, you have to do more than just ask. It's up to you to
well, that's why I had the document written up and by an attorney, and so that Devin would sign the paperwork, and he said he wouldn't fight me, and then he didn't show up to sign it. So I don't understand what the big problem is.
Okay, so how are we going to deal with you paying your child support till that happens then?
I don't know. I have a paycheck coming from Boyne River, and you can have that. Okay. But other than that, I have $34 to my name. My house is for sale, and I'm living in my car.
When are you getting that paycheck?
I don't know. It should be garnished. I probably won't even get a paycheck. It should be garnished by child support.
Do we have an income withholding, Ms. Krause, for any employers with Ms. Brink?
There is a potential income withholding, but it wasn't reported. So outside of her indicating where she's employed today, that process could take 6 to 8 weeks. So I can't guarantee that monies would be withheld from that paycheck.
Yeah, it should be. I've never had a problem with it not being withheld in the past.
Okay, well, we don't have the information from your employer, right? Ms. Kraus, is that what you're saying?
Yes,
She's
you
never,
do. Oh,
Correct.
they reported it.
hold on, Ms. Brink, Ms. Kraus.
An income withholding was sent, but until monies are withheld, we wouldn't be able to indicate if that amount would be withheld. But the employer was not reported. It's pending, so I can't guarantee that the employer received anything.
They did.
Okay.
They told me.
Well, we haven't received any money from them, so apparently they haven't.
I haven't gotten the check yet. I haven't even been, I get paid every 2 weeks. And I've already lost the job. They already fired me.
So you're
I'm
not
not
employed.
sure.
You're not employed is what you're saying.
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Okay. What about the disability? Where are you at with that?
I filled out all the forms that they requested from me and mailed them back in the timeline that they gave me. But I'm living in my car, so I don't have access to my mailbox anymore. So I have to contact disability today after I get off the phone or after I get out of court and report my address to be at my parents' house. Now there's no guarantee that I'm going to get my mail. My parents don't like me. So there's no guarantee that they're going to tell me that the disability paperwork comes. I'm going to have to, I don't know what I'm going to do because I don't have gas to get to their house. And they have me blocked on the telephone.
Your Honor.
Okay. Yeah, go ahead, Ms. Kraus.
In regards to her being homeless, she may be able to reach out to the local post office. They may have something for her in regards to obtaining a PO box, but she would need to check further into that.
Well, I don't have money to pay for a PO box.
They may have some options for you regarding if you're homeless right now. I don't know the details in regards to that, but it is some information that friend of the court has received in regarding post offices when people are homeless.
Okay, I'll look into that.
All right, well, here's Ms. Kraus, has there been, how many findings of contempt has there been in this case on Ms. Brink?
This would be a first finding.
Okay. All right, so Ms. Brink,
I'm not in contempt, Your Honor. I have no problem paying it. It's just I can't get a job because I have felonies. No one wants to hire me.
I do
I've already put
consider
out more applications. I'm not in contempt, though. I have no problem paying. It's just that I can't get a job. No one wants to
Okay.
hire me.
you are in contempt, first of all. I find specifically that you are in contempt because you aren't doing any of the things that I ordered you to do the last time, and you can't just
Your
say,
Honor,
well,
like what?
like fill out the forms for your disability.
They
Communicate
weren't
with-
mailed to me. How can I
You
fill out
just-
forms that weren't mailed to me?
I'm not going to
I
argue
called
about.
and asked. I
Okay,
called and asked.
now I'm finding you in contempt for continuing to interrupt me during this court hearing and inhibiting the court's ability to conduct this hearing. You're continuing to talk over me. I'm trying to explain to you.
I asked you a question.
You just told me that you're not getting mail at your parents and there's no guarantee that you're going to get your mail. So how do you know that you didn't get this? We sent it to the address that you gave us.
And I was living there up until Friday.
It's not my problem that you aren't getting your mail. All we
I
can do
am
is send.
getting my mail.
Obviously,
It's
you're
not making
not.
sense, Your Honor.
All we can do is send it to you at the address that you give us.
And you
then
didn't.
It's up to you. So you haven't followed through with what you were required to do.
Yes, I did. I called the child support office and asked about it, and they said it was too soon for me to be calling.
I'm gonna mute you now so that I can say what I need to say for the record here, because you're continuing to talk over me and I'm not able to conduct this hearing. So the court adjourned the previous hearing in August to give you an opportunity to submit the forms that were required to be submitted. That's your responsibility to make sure that that's done. We had this colloquy the last time about your address. You gave us an address. That's the address we've been using. If you haven't received the mail, that's between you and the post office and you and whatever is going on with the address that you gave us. All we can do is send out forms. If you didn't get them in the mail, then it was your responsibility to contact the friend of the court, go to the friend of the court, make arrangements to get those forms and fill them out. But that's squarely your responsibility. It's your responsibility to pay child support for your child. That's still your child. Your parental rights haven't been terminated. As far as I can tell, you haven't done anything other than say you want that to happen, to make that happen. So you haven't paid child support. You haven't complied with any efforts of the friend of the court to give you options outside of paying child support. So the court finds that you are in contempt, because this would be a first finding of contempt. The court finds that you should be sentenced to 45 days in the Otsego County Jail. The court is going to order that you turn yourself in to the Otsego County Jail by 5 p.m. today. That's September 3rd, 2024, to begin serving the 45-day sentence. If you fail to turn yourself in to the Otsego County Jail by 5 p.m. today, then the court will issue a bench warrant for your arrest. Ms. Krause, if you can prepare an order to reflect the ruling of the court on that today.
Yes.
All right, that's all for this hearing today. The court's going to disconnect from Ms. Brink at this time.
4 months later.
Mr. Hildebrandt, are you able to hear me okay?
Yes, sir.
All right, we're on the record in Brink versus Hildebrandt, case number 11145050. The record should reflect Mr. Hildebrandt is present today by Zoom video. Ms. Brink is not appeared today. This hearing was set for 9 a.m. It's now 9:26. She is not present. Ms. Krause, can you tell me the status of this case today, please?
The plaintiff has a support obligation of $197, and the total amount due is $9,715.16, which includes this month's obligation. There has been no payment since the last hearing, when the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. The last payment that was received was from a prior income withholding in the amount of $206.47 in February of 2024. There has been no communication with the plaintiff.
Thank you. Mr. Hildebrandt, was there anything you wanted to say in regard to this matter?
Not regarding the support, but I do have a couple questions, otherwise.
Okay, what are your questions?
It's actually about Chelsey's mental health records to further diagnose my daughter and the issues that she's got. I was just curious how I go about getting those, because I know they've been brought up in court before, but just, I don't know how the proper channels to go through to get that. I was looking if you could probably provide me a little guidance on that.
Are they documents that have been admitted as part of prior court proceedings as exhibits?
I believe they were. I know they were brought up and discussed in court, and that gave, when we were doing our custody here, that gave Bill's lawyer the opportunity to bring them up and discuss them in court.
Okay. Ms. Krause, I saw you kind of nodding your head. Was there anything that you wanted to add to this?
Yes, it is brought to my attention that the plaintiff is actually in Otsego County Jail as of yesterday. I didn't check the inmate list this morning. I apologize.
Okay, all right. Okay, so Mr. Hildebrandt, to answer your question, first of all, if those are part of the court file, you can come to the clerk's office here in Otsego County and you can go through the file if those records are part of the file, like if they've been admitted as part of prior hearings, then that's a public file. So you're more than welcome to come in and see what is in the file that you can review. To the extent that they're not part of the file, that is something that would require me to give you legal advice. I can't ethically do that.
Okay.
So you would have to gather some more research on your own, or maybe consult an attorney as to how you would be able to obtain those records.
Okay.
Because they're covered by all kinds of different protections regarding confidentiality and so forth. That doesn't mean you wouldn't have a way to get them. It would be something that you would have to consult an attorney about or research.
Okay, thank you, sir.
Okay. All right. In terms of going forward, although we do have that additional information, the court's going to issue a bench warrant for Miss Brink. Since we do have her lodged already, Ms. Kraus, I think what we'll try to do is set that for a arraignment hearing on Wednesday when I have my criminal docket. Mr. Hildebrand, did you want to be present for that?
Yeah, please, if I could.
Okay. When we get the date and time of that, we can contact you. Ms. Kraus, do you have Mr. Hildebrand's contact information?
Yes, we should.
Okay, so Mr. Hildebrand, we'll let you know the date and time, but I'm going to try and get that on the docket for Wednesday at some point, and you can join by Zoom as you're doing today.
All right, thank you. Yes, sir.
Okay. All right, thank you. You're free to disconnect at this time, Mr. Hildebrand.
All right, have a good day.
All right, we're going to go on the record. This is Chelsey Brink versus Devin Hildebrand. This is file number 11-14050. This was set for a contempt hearing today. We do have Mr. Brown present on behalf of Ms. Brink. Ms. Kraus is present on behalf of a friend of the court. And I see Mr. Hildebrand is also connected. I do not see Ms. Brink connected.
Your Honor, she is lodged in the Otsego County Jail still.
Oh, she's still currently lodged?
Yes. She is going to be sentenced on an underlying misdemeanor matter in maybe 10 days, and she is not going to be bonding out anytime soon.
Okay, so in light of that, Ms. Kraus, how does the friend of the court want to proceed today?
So do you believe that it would be over 60 days in jail then? Because if that would be the case, we would just consider dismissing the show cause in regards to if that's the case.
Her next criminal court hearing for sentencing, I believe she'll have at least 40 days in.
All right.
I guess.
Oh, go ahead. I'm sorry.
I was just saying, based on that information, it appears that it would be close to the 60 days. So at that time, we would consider just proceeding with the dismissal and then see where things are at. And if needed later, at a later date, move forward again.
All right. Do you want me to set this for another hearing next month to see what the status is?
Would it be still in front of you, Your Honor, or with Judge Hesslink? Because we could potentially adjourn it out to possibly April 25th in front of Judge Hesslink and go from there.
All right. I think given that she's lodged and going to be sentenced here in 10 days, I think moving it out to April makes sense to me to see what her status is at that point. Because obviously, and I'm directing this to Mr. Hildebrand. Mr. Hildebrand, you know, when she's lodged in jail, that limits our options in terms of proceeding with contempt from a statutory standpoint. So I think if we set this for hearing in April, that's 2 months. We're going to know at that point what her status is and whether we can proceed with contempt or whether we have to dismiss this one and start a new proceeding based on future failures to pay if that occurs. Do you have any questions about that, Mr. Hildebrand, at all?
No, I understand that you aren't going to get anywhere with her being locked up and whatnot. So I'm all right with setting it out till April or whatever, just as long as it doesn't get swept underneath the table.
No, it's definitely not going to get swept underneath the table. We'll keep the feet to the fire, so to speak. So yes, Ms. Kraus, you can go ahead and set that then in April before Judge Hesslink.
Thank you.
All right, thank you, Mr. Hildebrand and Mr. Brown. You're both free to disconnect at this time.
Thank you.
Thank you.
Two matters involving Chelsey Brink, both friend of the court matters. First one is Chelsey Brink in 2013-15199-DC. And the second one is involving Chelsey Brink. It's 2011-15199-DC. 14050-DS. Both of them looks like arraignment cases on failure to pay. So do we have?
Here, I believe. I didn't show up to court on Monday. My alarm didn't go off by the time I woke up and realized it was too late to join. My attorney did go though, and I did pay $100 towards my child support before that. So that's where I'm at.
All right, let me hear from the friend of the court first. Who do we have speaking on behalf of these cases, please?
Depends on which case you want to handle first.
You got both, one for each?
Yes.
All right. I guess it doesn't matter. Let's do William Mason, William Mason versus Chelsey Brink, which is the 213 file. As to that case?
That would be me.
All right. What is it that the friend of the court is asking for in this case?
Well, we are seeking first contempt as we received information about a property that Ms. Brink previously disclosed in another hearing has recently sold, and she has not made any efforts to make any significant payments out of available.
I paid.
Or exercise due diligence.
I made a payment of $100. That was all I could afford.
Ms. Brink, you're going to be given an opportunity to have your say. I just need to hear it from everybody at their time to speak so that we're not talking over each other. So this is the friend of the court's turn. I'm going to give you your chance to speak in just a minute. So don't worry. You'll have your opportunity. Let them speak, and then I'll let you speak. All right? Go ahead.
So the monthly obligation that Ms. Brink has is $202 plus an additional $50 ordered on arrears. The balance on this case is $12,753.72.
All right. Now, Ms. Brink, I'm going to turn to the other case so we have both of them out on the table first, and then I'll let you have your opportunity as well. So the other case is Chelsey Brink versus Devin Hildebrandt. That's the 2011 file. So Ms. Kraus, could you update me as to that one?
Yes, her obligation, she's a plaintiff on that case. Her obligation is $197 a month. The arrearage in this case is $10,209.16. We did recently receive a $100 payment on April 15th for this specific case. Out of that $100, $49.37 dispersed to the case. Chelsey did report an employer on March 30th. And also indicated a change in address, but refused to submit that in writing. It was verified at a later date with postal information, but it does appear that she's no longer employed at that employer as of March 27th.
All right. Now, Ms. Brink, this is your opportunity to tell me what it is that you want me to know about all of those things. So go ahead, ma'am.
Yeah, well, first, I did make a $100 payment. That was all I could afford at the time. I'm homeless. And I've been homeless for quite some time now, so I'm kind of drifting, going where I can. I was working at Italia Gardens, and I'm not sure what happened to be able to explain why they fired me, but they did. He just basically said things weren't going well. I had a workman's comp claim that he didn't want to pay, so there was that piece of it.
What was the name of the business that you were working at?
Italia Gardens.
And where's that located?
It was in Davison, Michigan.
All right.
So, but that's no longer.
Yep.
And you know, my kids have been out of my life for 10 plus years now, and both of their parents are remarried. My son's been adopted twice. My daughter has been adopted once. I'm not even sure why I'm still required to pay on these children. They're not in my life, and I don't have responsibility toward them anymore. So it seems to me not fair. A lot of this friend of the court totals, the monetary amounts, got accumulated while I was in jail for a year, that still hasn't been cleared up, and I doubt it ever will be. But I am making my best efforts. I'm in jail. I'm not sure how long you want to keep me in here, but when I get out, I plan on looking for a job again and starting the whole process over. Like I said, I'm homeless, so it's hard for me.
How long did you work at Italian Garden?
About 6 weeks.
Did you make any payments other than $100?
I reported the income to the front of the court, and they said that they would take it out of the checks. I never even got my last paycheck because I had to come back up north. So that's out there somewhere still. But no, the $100 is all I could afford at the time. I had intentions of making $100 payments every month, from here forward. But right now, that was only a couple days, a couple weeks ago. What day did she say? The March 20th? Something?
You were employed in March, but you're no longer there. You made a payment in the middle of April for $100.
Middle of April, yeah. So it's only been a couple weeks, not even really. Today's April 30th, so middle of April. I mean, 15 days ago at the most, 2 weeks ago at the most, I made that payment. I'm exhausted because I'm homeless. So not that that's an excuse, Judge, but I've never missed court. Never. I don't do it. I don't miss it. And Larry was there, so I'd rather you just sentence me now so that I know what I have going on moving forward and can be prepared in here for what I need to do.
Well, what you've been telling me is that you can't afford to make payments, as opposed to, I can't afford to make payments and I didn't do anything.
I can't pay the whole amount. I can't pay the whole amount. I'm homeless. I'm barely making ends meet as it is.
You're not asked to make.
From walking, it's hard.
Okay. Have you filed a request to lower your child support based on your current income levels?
Yes, I did. I asked front of the court to mail it to me. They did not do that. They said that they required me to change my address with them on paper, but I was cleared on in Davison, Michigan, and I couldn't get to the courthouse down there. I was on foot, and I couldn't get to the courthouse down there. And to be able to mail in the paperwork that they were requesting. It's on my to-do list, but I've been traveling, going from place to place, couch surfing and whatnot. So sleeping in my truck.
Your Honor.
Yes, ma'am.
In regards to motions, the conversation that I had with her on March 3rd in regards to asking for case information on both of her cases, the friend of the court did, because the motions didn't have any case specific information, printed out a postal to send to her with those motions to the address that she indicated that she was residing at. So we did do that in regards to previous contact when reporting employment.
I never received them.
We've had discussions in regards to when you start working, payments are expected to be paid when you receive paychecks, because income withholdings can take 6 to 8 weeks. But when she does obtain a job, she's usually not there long enough for an income withholding to send money. So there was never any money received from the employer that she reported.
Right, which is why I made the $100 payment. And trying to get my child support, the first $12,000 or so of the back child support is all from when I sat in jail for a year. And that's just not right or fair to me. And actually, it's probably more like 19,000.
Ms. Brink, when was the last time you were in jail for a year?
2017.
That's
when my child support first became activated. And they did
Right,
it
that's
while
8.
I was sitting in jail for a whole year. They accumulated it for a whole year.
Ms. Brink, that's 8 years ago. Even if you were incarcerated in 2008,
I know, but I'm
2017,
saying I'll never be able to pay that money back, not at this rate. And I'm trying, Judge. It's not for a lack of effort. I walked the entire main street of Davison and put an application in at every single business, every single one. Down the street and back the other way when I was living down in Davison. And I have full intention of doing that up here again. And I'm going to go to Traverse City and stay in the homeless shelter or stay in my truck. You know, I mean, who wants to hire a smelly person that's homeless, though? I mean, I'm doing the best I can, Judge. It's hard. I relied on my child support money to pay my bills when I had full custody of my kids, plus work. And when I lost my career, I lost my kids, and that's all my money. I can't do it. I just can't, Judge.
Ms. Brink, the issue is when you were working, you didn't send any money into the friend of the court. $100 in 6 weeks is not a payment out of each of your paychecks.
But that's the thing, is that I only got paid 2 times. I didn't get 6 weeks worth of paychecks. I only got 2 paychecks.
Which would have been at least 4 weeks worth of paychecks, right? You got paid every other week?
No, I got 2 paychecks of the whole time. I don't even think I was there 6 weeks. Honestly, I don't. But I only got 2 paychecks the whole time I was there. I promise you, Judge. I wouldn't lie to you about it. I know that we're in court. I'm not going to lie to you. And I didn't even pick up the second paycheck because I had to come back up north.
All right, Ms. Brink. Doesn't sound to me like you believe that you've done anything wrong in this case, so I'm going to set this matter for a hearing.
Judge, I'm saying I know I missed court, and that's why we're here talking about this again. And Larry advised me that you weren't going to pursue jail time or anything like that because I made the $100 payment, and I'm putting an effort to find a job again. And
Your Honor, if I could just mention a couple of things. I don't know how much Your Honor knows about the background. I have represented Ms. Brink in the past. Back in I know she said she did a year in jail. Back in 2021.
I went to prison I was locked up for 4 years from 2017 till 2020.
Yes, there was a prison stint. I also have some notes here back from June of 2023. There was an MI petition that was filed as well, just so the court has a better
I don't know that, Larry.
understanding of what's going on.
All right. Ms. Brink, are you telling me that you want to admit responsibility to failing to appear when you were supposed to?
I admitted to responsibility to that. Absolutely. I screwed up. My alarm didn't go off. I was exhausted. By the time I woke up, it was 10, 11 o'clock in the morning. And I thought, oh, real nice. They're not going to accept me now. And what do I do? So I just didn't go to court, which I guess looking back, I guess I probably should have tried to join in, but I figured the court was closed. And Larry texted me the same day or the next day and said, now you have a warrant. And I said, okay.
All right, Ms. Brink, I'm going to do this. I'm going to adjourn today's hearing for 30 days. I'm going to set a PR bond so that you can be released. The conditions of that are that you have to notify the friend of the court of a mailing address where you will pick up your mail on a regular basis.
Okay.
And so that you know when you're supposed to be in court. The second condition of that PR bond is it's going to be a $500 PR bond.
Okay.
The second condition of that is that you submit 10 applications a week to the friend of the court, indicating that you have applied for jobs, and as soon as you are able to obtain a job, that you notify the friend of the court of that.
Okay.
The third condition is that once you are employed, you begin to make some payments every paycheck. You're not going to wait for income withholding. You're not going to do anything else. You're going to make some payments on both of these cases every paycheck.
Yes.
You understand each of those 3 conditions?
Yes, sir.
All right. So in each,
I have a question.
hang on, let me finish. In each of these 2 cases, you will have a $500 PR bond. Okay, so that means if you fail to appear, you'll owe me $1,000 total. You
Okay,
understand that?
yes, sir.
All right,
I don't
now
have
what
to
is
pay anything
what is your
today.
question? I'm sorry, repeat that, please.
I don't have to pay anything today to get out?
That is correct.
Okay,
You don't have to pay anything today to get out. I'm giving you a big break here
yes, you are.
because
Thank
you owe an awful lot of money, but I think that you have done something to show me that you're trying. That's
Yes,
the $100, and you've made an admission that you failed to appear, gave me a good reason for it.
right.
But you've got to do better than you have been. You have to
Okay.
find a job that you can stay with. You have, and if you can't get that one, you got to get one that at least allows you to have a place to live so that you can make regular payments. Do you understand what I'm saying to you?
Yes, sir. Yes, sir.
If you believe that the numbers that the friend of the court says that you owe are wrong,
Uh-huh.
you need to file a motion to have me take a look at it so that I can correct that for you.
All right.
All right? You understand all of that?
Yeah, and when I get out, maybe I can file to see about having my child support adjusted to
That's
reflect
correct.
more accurate income.
Yes, but
It's
you need
not
to
so
file the
bad.
paperwork first. File the paperwork with the friend of the court so that I can review it, set a hearing date, and take a look at it.
Okay.
All right?
Thank
That's
you.
all for today then. Thank
I
you very
appreciate
much.
it. Yeah.
All right. Good morning, everyone. Welcome to the family court. This is Judge Hesslink. First case this morning is Chelsey Brink versus Devin Hildebrandt. That's file 11-14050-DS. We have Ms. Brink with us. I see Mr. Hildebrandt is with us.
Yes, sir.
All right. We are here today on two matters. One is a show cause continued from last month to see whether or not you've submitted a proper amount of job applications to the friend of the court for this week. And then the second one is a supplemental petition for show cause filed by the friend of the court, which alleges that you sold your house in March of this year. They've provided documentation of that from the county records. Indicates that the house was sold for $37,000 and that the only payments since that date total $98.74. So they're asking for a show cause as to why you shouldn't be held in contempt for failure to make a diligent effort to pay a more significant portion of the amount owed after the sale of the house. So as to the proofs for job applications, Ms. Kraus, has she submitted the 10 that are required this week?
She actually contacted our office and reported 2 employers. One has been verified and one was sent by electronic verification indicating she was not employed there. She had been previously, so I'm not sure if maybe she just hadn't started yet on that, but
Right.
I do have confirmation that she is currently working for sure at one. No income withholding is set up yet because there's more information that's required from that employer to do so.
All right. Ms. Brink, where are you working at now?
I got a job at Southwoods Pub and Grill, and I'm waitressing. I've been there almost Monday makes a week. And I'm sorry, this coming Monday makes 2 weeks. A week. And then
excellent.
I was hired at Meyer, but they're waiting on my background check. It's taking Otsego County a long time to get back to Meyer. But I was hired there on 6/30, I believe. And as soon as their background check comes back, then I should be good to go.
That's
They
really good
hired
news.
me 5 years ago when I first got out of prison, so I don't see why it should be a problem for my background check to be okayed.
Okay. Well, that all sounds good. Ms.
Your Honor.
Kraus,
I'm going to work at Southwoods for my own money, and then I'm going to work at Meyer to pay my child support, just like 3 days a week probably, because I don't want to
All right.
overdo myself. And I'm going to AA meetings. My home meeting is at 11:45 every day, so I'm going to have to switch meetings. And then I have, well, I guess that's really it, just the AA meetings going on.
Okay, all right. Mr. Brown wanted to say something. Mr.
I
Brown?
just wanted to follow up on what Ms. Kraus said. I know that they don't have an income withholding order yet, but Chelsey did indicate to me that her employer has received that. It just has not been processed.
Yeah,
All
when
right.
I talked to him yesterday, he said that he had to have his boss fill it out. So as soon as his boss gets in, his boss is really busy. It's the owner of the restaurant, and he's very hands-on, so he's a very busy man. And as soon as
Okay.
he gets a chance, he will fill it out.
All right. Ms. Kraus, is there anything else that Ms. Brink needs to do for the normal show cause proceeding?
Just maybe possibly just making payments until that is, because even if that paperwork is processed, it can take 6 to 8 weeks before money would start to be withheld.
All
I
right.
just want to
Ms.
say that the first $100 I made, I bought Christmas gifts for my kids, and because they didn't get a Christmas from me last year. So, and then I have $250 in the bank. I have to pay my car insurance because there's a delay on that. I was late on the payment, so I have to pay my car insurance first, my cell phone bill, and then everything after that is going to child support.
All right. Ms. Kraus, what is her
Well,
monthly
not
payment
everything.
supposed to
I
be?
need money to live on, but I'm planned on paying at least $100.
With the case with Hildebrandt, correct?
Correct.
The obligation is $197. That's just for current support. Arrears are $10,801.42.
All right.
And I'd like to see that get corrected because all of that came accumulated while I was incarcerated. And according to Judge Kevin Hesslink on Brian Morgan's case, he said that if you're incarcerated for more than 6 months, child support doesn't accrue or accumulate, and mine accumulated while I was incarcerated. So I'd like to see that get straightened out.
All right, Ms. Brink.
I don't know what I have to do.
Yeah, I'm going to tell you what you have to do right now. You need to file a motion.
Hang on, let me get a piece of paper.
Okay.
Go ahead.
You need to file a motion that says the dates upon which you were incarcerated so that the friend of the court can review to see if there was any increase in the amount while you were incarcerated. And then you need to show whatever documentation you have to prove that you were incarcerated during those time periods.
Well, I don't have any. I got rid of all my, after 1 year, they told me on parole that I had to keep my paperwork for a year, and then after that, I didn't have to keep it. So I got rid of all that paperwork, but I might be able to call the prison and see if they can send me something. I'm not sure.
Your Honor.
All right. Yes, Mr. Brown.
I handled a lot of those cases. I can get that information.
That would be outstanding. Thank you for that assistance. So Ms. Brink, if you can contact Mr. Brown, he may be able to assist you with that, but you need to file a motion that says when you were incarcerated and proof of those incarceration dates. And then that information can be given to Ms. Kraus and she can do an investigation as to what, if any, amounts were increased during that incarceration period. And then that can be set for a hearing in front of me and we'll make a decision on it.
Okay, thank you so much.
I'm sorry, I didn't hear what you said.
I said, okay, thank you so much.
All right, yep. Ms. Kraus, is there an ordered on arrears amount in the Hildebrandt case?
There is not.
All right, I'd like to have a recommendation from the friend of the court in writing as to that amount, and we'll have it set for hearing at next month's court date. So that Ms. Brink has an adequate opportunity to review it and see whether she agrees with it or not. And if she wants to disagree, then she'll have a court hearing for that time period. All right, Ms. Brink, the current monthly amount that you owe now that you're working is $197 each month. So we're going to adjourn the show cause to see that you are making that payment. You no longer, because you're employed, you no longer have to do the 10 applications per week. So just keep working, but you need to make your payments now of $197 each and every month. So I'm going to adjourn.
Yeah, I'll put
the
good
first.
faith effort into it.
Okay. I'm going to adjourn the first show cause then, because you're working. So I'm glad to hear that. And we'll monitor whether or not you're making your payments of $197 each month for the next few months. And if you are, then we'll get rid of the show cause on that. So next, I'm going to turn my attention to this supplemental petition filed by the friend of the court regarding the sale of your home. It's my understanding that the home was sold in March for a price of $37,000, and the friend of the court has not received any significant funds since that time towards your arrearages. Was the home sold in March?
Yes, sir.
And were there any amounts
end
that
of
you
March.
received? How much did you receive for the home?
I received one payment of $30,000 and one payment of $7,000.
All right. And why is it that you have not made any additional payments then towards your child support arrears?
Well, can I tell you the whole story? Do you have time?
Well, you can do it in the next 3 or 4 minutes. Yes.
Okay, yeah. So I was living so before I sold the house, I was incarcerated. I got because of the assault on Sean Conradi, who was a heroin addict living in my house. I gave him a second chance. He was living in his truck, starving to death, he told me. So he ended up assaulting me. I called the police several times to try to have him removed from my house. They put me in jail because they were scared I was going to get seriously hurt. I did 38 days, and while I was there, I went to sober living. When I got out of sober living is when I decided to sell my house. While I was in sober living, I got engaged to Brian Morgan, and he moved me down to Davison, Michigan. Well, he assaulted me very, very, very badly, went to jail, and the landlord wouldn't accept like MEMSCA help or any kind of help from me to pay the rent, and he locked me out while I slept. And that happened right after I sold my house. So I bought a camper, and I was living in my camper. I spent $7,000 $8,500 on that. And then I had no vehicle, so I spent $6,500 on my truck. So that was, and I got a really good deal on the truck. I didn't get screwed or anything like that, pardon my language. And so I was living in my camper. Well, I decided that I lost my job at Italia Gardens. So I decided to come back north, and my camper got wrecked. And so I went under I don't know what it's called, but I think it's like an awning thing at Travel Lodge, and it ripped the AC unit off and put a big hole in the roof. And then, so I couldn't sleep in that anymore. I couldn't live in it anymore because of weather. Well, it got towed from McDonald's because when I went through McDonald's drive-through, something caught on the side and ripped the siding off of it. And then, so I spent the rest of the money on hotel rooms to live in. I did sleep in my truck some of that time. I was trying to save money, but by the time I got back up here, most of the money was gone. So what I could afford, I paid out of that money. But most of the money was gone. I had to buy a vehicle. I had no vehicle, and I had to figure out something where to sleep,
The friend of the court says that you paid a total of $98.74.
That's not accurate. I paid $200.
Since
$100 bills right there, and I got receipts for both.
They were split between the two cases.
I understand that, but I did pay $200.
All right, so almost 100 of it was credited to this case, and the other amount went to the other case.
Okay,
so
good.
200. Okay, so you got $37,000. You spent $15,000 in total on a camper and a truck. So that means you spent $12,000 on yourself. On yourself, without making any payments for your kids?
I made 2 payments.
$200. So you
Yes,
spent
sir.
$11,800 on yourself instead of paying it towards your kids.
Well, I did the best I could, sir. I'm sorry that
No,
makes you upset.
that's not the best you can. That's being selfish.
It
It's
was.
spending money on yourself instead of sending it to your kids.
Well, I haven't spent money on myself in 5 years.
Your Honor. Your Honor, that'd be 22,000 rather than 12,000.
You're absolutely right. Thank you very much for the math correction. I appreciate that.
Well,
Brink,
either way, I'm working now, so payments will come.
Here's what's going to happen with those payments, Ms. Brink. They're going to go up substantially. I know that the money's gone now, but I'm going to take that into account when I set the ordered on arrears amount.
You have to base it off what I'm making. You can't just increase it because you want to and you're not happy about my case.
And I will, but I have discretion as to where it's going to be placed. Ms. Brink, I'm not going to have this argument with you today. I'm simply telling you what I'm going to do. You can object to it next month, Ms. Brink. You can object to it next month when we have the hearing on it, but I'm telling you what I'm disposed to do so that you can prepare yourself for it. I am disposed to, in my discretion. Ms. Brink, I'm talking, you'll wait. I'm disposed in my discretion to raise the amount that you're going to be paying on the arrears amount because you have wasted $22,000 on yourself instead of paying child support. You could have paid off the entire amount of child support that you owe in this case and probably in the other case. All right. We'll have you back in a month. Ms. Kraus has taken notes. She has noted that I will use my discretion to increase the amount of ordered on arrears amount next month to the most amount that we possibly can under the recommendations. So that's all for today. Thank you very much.
Is there a Mason case?
There is, and it'll be called in just a minute, but the next case is not that case.
Okay, I do have to work at 11, so just so you know.
Thank you very much. I'll get to you as quickly as I can.
Thank you, sir.
All right. Similar to the last case, we're here on 2 matters. One is a normal show cause to determine whether or not you're meeting your monthly obligations. And then we have the supplemental petition to show cause regarding the house sale as well. I understand from the last case that we had that you are now employed and your employer is in the process of doing a withholding order and also that you have sold your house and the funds have been spent. So I'm going to enter the same order in this case that I did in the last case, unless there's some different information that you want to tell me about for this particular case.
I don't think so. I think everything I said is true, and I think I've said everything that I need to say, except for that I do have motions filed for parenting time, and I'd like to get my children over to Petoskey, where I'm living at the Mary Margaret House, to the Children's Advocacy Center. I'm working with APS as well. I have an open APS case for myself and my parents.
All right. Well, the parenting time, Ms. Brink, parenting time goes to Mr. Legal as the referee first. So you'll have to deal with him.
Actually, Dawn Ellison.
Your Honor.
Dawn Ellison
that has been changed to me, hasn't it? All right. I remember that. All right. I don't see any motions that you filed in the court file for that, though. Have you filed those motions yet?
Yes. It's scheduled July 25th at 10 a.m.
Your Honor.
Yes.
In regards to that, there was a motion that was filed, but there are case notes from the county clerk that was sent back to her with some instructions to complete the fee waiver or send payment. So it would have to be set for a later date.
All right, all I can say, Ms.
I
Brink,
did
is
do
I
that
don't,
and I already mailed it in.
well, it hasn't reached the court file yet. So once it reaches here, I'll
Sir,
have
I
that
haven't
hearing
seen
on
my
the,
kids in 2 years.
okay, Ms. Brink, once it gets here, we'll have the hearing when it's set. It's just not set for today.
Right, okay.
I'm not denying you an opportunity to have a hearing. I'm simply saying I don't see it in the court file at the moment, which means it simply hasn't gotten here yet. I'm sure that it's on its way. And once it gets here, we'll have a hearing on the date set for that hearing. But I can't do it today because it's not set for today.
Right.
All right. So on the friend of the court matter, we will do the same thing in this file that we did in the other file. Because she's now employed, she can start making payments. Ms. Kraus, what are the monthly payments that she needs to make in this file?
This specific case would be $252. There was an ordered on arrears order back from 2018 requesting $50 towards overdue support. Her arrears on this case.
Which I was incarcerated.
All right, Ms. Brink, you're going to have a chance to make that motion in this case too. We're going to get to that, but you need to let people talk until they're done, and then you can jump in. You can't just talk over people. All right, Ms. Kraus, go ahead.
The arrears on this case is $13,107.09.
All right, Ms. Kraus, I'd like to have you do an ordered on arrears recommendation in this file, just like you did in the other one. I realize that there's $50 a month being paid, but back when that was set, I believe that there was probably a much less, a much reduced arrears amount. So I'd like to have a current recommendation, and we'll schedule that for hearing at the next month's court hearing. And then in the meantime, Ms. Brink, you need to be making payments of $252 a month on this file, and we'll review that next month to make sure that you're able, how well you did on that. And then you can also get with Mr. Brown to get the documentation that you need to make any motions regarding the same thing that you did in the last file about the incarceration time, if you believe that the arrears amount is not accurate and grew during the time that you were incarcerated.
It did, and I will. The only thing I was going to say is that, yes, I was incarcerated from 2017 to 2020, I was incarcerated. So all of that is inaccurate. And I will be filing a motion for that. And I was going to say something else and I can't remember, so I don't want to waste your time. Oh, Mr. Mason has been letting me talk to John, my son, on the phone. So I will say that is progress in a positive direction. But the only complaint I have is that he is talking very poorly about me, my mother and my father, probably my sisters and brother. And he's talking very badly about my family in front of my son, and that's causing my son's autism to be worse.
All right, Ms. Brink,
so I'm concerned.
all of those things are parenting time issue things. So I can't consider that today. So when we have the hearing on the parenting time motion, you can bring all of that up to my attention then, and I'll consider it at that time. All right, ma'am?
Yes, sir. And I do want to tell you, too, that I'm working with NEMSCA and working on getting a place, and I should be in my place, like, within the next month. But the only thing else I was going to say is, am I going to get a whole month between court hearings? Because it's only been 2 weeks since I've been in court. And I'd like to see myself get a whole month in between court hearings so that I have a chance to pay on my child support before I get lectured again.
We try to give you as close to a month as we possibly can. There are some days, some months where it's not possible due to scheduling for other reasons. But we will give you as much notice or much lead time as we possibly can. So this will be scheduled next month at the normal time. I don't know whether that's going to be exactly a month from now or not, but it'll be as close to that as we can possibly get. All right. Is there anything else, Ms. Brink?
I need to update my address with the court as well.
All right. You need to do that in writing to the friend of the court, please.
I'm sorry?
Do you want to give it to us now, and then you also need to send us a note so that we have it in the file?
Yes.
Go ahead.
And that's temporary, so I'll have to update my address again once I get it into my apartment in Vanderbilt.
All right, if you would send that to the friend of the court in the mail as well, so that they have that for their file, so that they make sure that they keep that
Okay.
accurate as much as possible. I'd appreciate that. All right,
Sure.
that's all for today, then.
Okay.
Thank you very much, ma'am. Good luck to you next
Thank you.
month.
Your Honor,
Thank
can
you.
would you be able to request that we update the address? Because then we can do that in our
Yes.
system if you order it.
Yes, please. Chelsey Brink.
Chelsea's actually here. I don't see her name.
Well,
Your Honor,
yes, good morning.
I have tried to contact Chelsey. It appears her phone may have been disconnected, so I'm uncertain of what's going on.
All right, well, we'll just call the cases and see where we go from there. So, but thank you for the information. All right, the first matter on the court's docket this morning. Oh, by the way, welcome. Good to see all of you. Thank you for being here today. The first matter on the court's docket is Devin Hildebrandt and Chelsey Brink. That's file 11-14050-DS. This is scheduled for a friend of the court petition and hearing regarding ordered on arrears amount and also a show cause amount. I do see Mr. Hildebrandt is with us. Mr. Brown just informed me that he's tried to contact Ms. Brink and was unable to, as her phone appears to have been disconnected. Ms. Kraus, have you had any contact from Ms. Brink?
I have not, but she did report a new employer on August 15th.
Are we getting income withholding from her?
We are not receiving income withholdings. She did make a payment that dispersed to 2 of her cases on July 22nd. $43.37 was applied to this specific case based on the disbursement policy.
All right. Mr. Hildebrandt, have you had any contact with Ms. Brink recently?
No, sir. Besides, my daughter had a little bit of contact with her, but that was probably the end of it.
All right. Did you receive the small payment that's been made recently?
Yeah.
All right. What I intended to do today was to find out if she'd made a payment, and if she did, to continue the case till next month to make sure that she continues to make payments. But I also wanted to set an ordered on arrears amount because she owes you quite a bit of money in back child support. And she's not got a specific amount that she's supposed to be paying on that. Ms. Kraus, could you, I know I read your petition. You're asking for $197. I'm sorry, $99 a month to go towards arrears. Is that correct?
It is, and I just wanted to mention in regards to line 3 that it indicates the court would use discretion when determining that amount as the plaintiff's sale of their home and payment history would be considered.
Yeah, I do recall that. It's my understanding, my memory that she received about $37,000. Is that yours, Ms. Kraus?
I do believe so, yes.
All right, so she got about $37,000 according to her testimony last month when we had a hearing on this. And it's my memory also that she spent all of that on purchasing vehicles and staying in hotels as opposed to giving any of that to child support. Mr. Hildebrandt, did you receive any of those funds from her sale of her house in child support amounts?
No.
All right. Under those circumstances, I believe that an additional amount is appropriate over that. At $99 a month, she owes, Ms. Kraus, is the dollar amount of $10,800 or $801.42. Is that still accurate relatively?
That is accurate as of July 11th.
All right, so it might be a month's worth more than that, but so that's going to take, by my math, it's going to take 9 years to pay off at $99 a month. So I'm going to up it to $150 a month because she had those dollars available to her. She may have spent them now, but it's clear to me that she didn't spend them on child support. So we're going to set the order on arrears amount at $150. still going to take her approximately 6 years to pay that off at that rate. But at least it's something that Mr. Hildebrand can get while the child is still in the house with him, as opposed to wait until the child is too old to do anything with it. So we'll set it at that amount. She's failed to appear, but she had proper notice of today's hearing. So that amount will be set on the ordered on arrears amount, and then we will adjourn out the show cause for another month to make sure she pays. If she doesn't pay next month, please let me know. We'll schedule this for next month, and if she doesn't pay, we'll do a show cause on that, or actually I'll consider contempt at that point. Any other questions that you have, Ms. Kraus?
I do not. Thank you.
Mr. Hildebrand, is there anything else that we can do for you, sir?
No, sir.
All right. Appreciate you being here. Have a good day.
Thank you, you too.
All right. While we're on the matter of Chelsey Brink, let me call up the other case that she has as well. This is the matter of Chelsey Brink and William Mason, file 13-15199-DC, set for a order to show cause on monitoring her payments, as well as an ordered on arrears amount. Do not see Mr. Mason present with us. And Ms. Brink, we just had a case on in which she failed to appear. Her attorney did not have any contact with her, tried to call and the number was disconnected. The other respondent parent had no contact with Ms. Brink as well. The friend of the court had no contact with Ms. Brink. Ms. Spillane, have you had any contact with Ms. Brink on this matter?
No, sir.
All right. Has she made any payments on this file in the last month?
We received $50.63 in July, but nothing yet for August. But as the previous caseworker reported, she just did indicate she has new employment, so the income withholding order hasn't taken effect just yet.
All right. It has been sent out, however?
I believe so. I'll double check real quick.
All right. All right. Given the fact that she has made a payment within the last month or so, I'm simply going to adjourn the show cause to see if she makes her payment for this coming month. If she does, I won't hold her in contempt. If she doesn't, I will. As to the ordered on arrears amount, the request from the friend of the court is for $101 of overdue arrears, which is 1/2 of the current monthly amount. I'm going to change that to $150 a month, as I did in the other case, because at the last court hearing that we had, Ms. Brink indicated she received $37,000 earlier this year from the sale of her home and made absolutely zero payments and $0 towards her ordered on towards her arrearages, which in the other file were $10,000, which in this file is in excess of $13,000. For that reason, I'm going to up the payment to $150, because that $101 is going to take in excess of 133 months, which is almost close to 12 years, which is way too long to repay. So even at 150, it's still going to take her 8 or 9 years, which is quite a lengthy period of time to repay a debt. But at least it gives us a chance to have the child to still be in the home when the arrears amounts are received. So we'll set the arrears amount at $150 a month, and then we'll adjourn the show cause to next month to see if she's made her payments. Anything else we can do today in this case, Ms. Spillane?
Oh, sir.
All right. Thank you very much. That's all for that case. The offense of police officer assault, resist, or obstruct, in that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Daniel Gertz, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing your duties. That is a felony offense that has a maximum penalty of 2 years and or a $2,000 fine. Do you understand the name of that offense, ma'am?
I'm not really sure what you're saying, but kind of. I have resisting arrest?
Yes. That's count
Right.
1. As a maximum penalty of 2 years and $2,000. Do you understand that?
Yeah.
Count 2 is the same kind of charge, resisting arrest. The name of it's called police officer assaulting, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jacob Depew, a police officer of the Gaylord City Police Department who you knew or had reason to know was performing his duties. That also is a felony offense with a 2-year and/or $2,000 maximum penalty. Do you understand the name of this charge in count 2 is also police officer resisting? And do you also understand that that has a 2-year, $2,000 maximum penalty? All right. In addition to that penalty, there's also a habitual offender notice being sent called fourth offense notice, which enhances the penalty. It says that you did on or about October the 13th of 2020 were convicted of the offense of resisting and obstructing police in the 46th Circuit Court of Otsego County. On or about February the 5th of 2019, you were convicted of resisting and obstructing police in the 46th Circuit Court for Otsego County. And on or about February 5th of 2019, you were convicted of the offense of attempted arson preparation to burn a building, also in the 46th Circuit Court. And because of that, the underlying 2 offenses have a maximum penalty of, Ms. Brucker, this says life, but I don't know that is it third offense that doubles it, or is it fourth offense that mandates the life sentence? Excuse me, the 25-year sentence.
I'm sorry. I think it should be 15 years, but let me double check that. I might have selected the wrong prompt when I did that. I'm sorry. If I could just have 1 second.
Yep, go ahead. Ms. Brink, she's going to check to see if the information that I have on my paper here is accurate.
All right.
It would be 15 years, Judge, and I'll get that corrected.
All right, thank you. So Ms. Brink, with the habitual offender notice, the maximum penalty is now 15 years in prison. Do you understand that?
Yeah.
Count 3 alleges that you did commit the offense of retail fraud in the 2nd degree. That is that in a store or its immediate vicinity, that is Walmart, when it was open to the public, you did steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000. That's a misdemeanor offense. It has a maximum penalty of 1 year and/or $2,000, up to 3 times the value of the property that was stolen. You understand the name of the offense to be retail fraud, that is shoplifting?
Yeah.
You understand the maximum penalty is up to a year in jail and/or a $2,000 fine?
Okay.
All right. Right now you have certain rights. I want to tell you what those are. You have the right to plead guilty, not guilty, or no contest, or excuse me, stand mute. You have the right to have a trial by a judge or by a jury, and you have the right to have an attorney. As to your trial rights, you have the right to see, hear, and question all the witnesses. You have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You have the right to testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal if you wanted to any error that occurred. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
Yeah.
You have any questions about any of those rights?
No.
All right. Mr. Brown, have you talked to Ms. Brink about court-appointed counsel?
I was not really able to get that far, Your Honor, but I am going to say that she is. I currently represent her on a few other cases.
All right. Ms. Brink, I'm going to appoint an attorney for you. In the past, we've dealt with each other, and you've been eligible for court-appointed counsel in the past. So I'm going to do that now. Mr. Gilo is going to assign the specific attorney. It may be Mr. Brown, it may be somebody else. But right now I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with your attorney. Because you're charged with felonies, I'm also going to set some court hearings on a quick basis so that those protect your rights as well. The first one is called a probable cause conference. That's a chance for your lawyer and the prosecutor to discuss the case quickly to try to resolve it. That'll happen within the next 7 days. We'll also set a preliminary examination date within the next 21 days. That's a chance, that's an opportunity for the prosecutor to prove in court a small amount of evidence called probable cause that you committed the crimes that you've been charged with. Do you have any questions as to the hearing dates that we just talked about?
Oh, I didn't really hear you though.
Do you want me to explain what a probable cause conference and a preliminary examination date is?
Oh, no. I get it. I thought you were setting dates, like giving me dates.
Nope, not yet. All right, what I'm going to do next, Ms. Brink, is I'm going to ask the lawyers about bond, and then I'm going to give you a chance to tell me what you want me to hear about bond as well. So, Ms. Bruker, could you, any thoughts on bond?
Ms. Brink is currently on bond for a trespass charge that we're set
No, I'm
for.
not. There was no bond set.
Okay.
Ms. Brink, she gets to talk, and then you'll have a chance to talk afterwards. So I'll listen to you what you want to say, but you got to let her talk without interrupting her, please.
And she's set for an upcoming trial in that case. She was recently convicted of assault and battery back in February. And she does have a history of felonies and misdemeanors on her record that are assaultive as well. I would ask for the standard terms and conditions of bond, including that she not re-enter the Walmart store. I would ask for the court to order that she report to community corrections. I'd ask for the court to order that she follow through with any of her community mental health appointments and treatments. It appears that this crime, as well as her trespass charge, are probably related to some of her mental health issues. So I wrote on the bond sheet a $10,000, 10% bond. I'll leave that to the court's discretion. When Ms. Brink is out in public, she violates the law. She fights with police. We need to make sure that she's safe and the public are safe. But I also recognize that she does need her mental health treatment.
Mr. Brown, your thoughts?
Hi, Your Honor, as the court stated, is familiar with Ms. Brink. She does suffer from some mental health issues that she's seeing CMH for. I would ask the court to take that into consideration when setting a bond if she has appointments coming up, but definitely don't want her to miss that. If she's taking any kind of medications, I want to make sure that she is getting the medications that she needs. Other than that, Your Honor, I would leave this up to the court's discretion.
All right, Ms. Brink, this is your chance to tell me what it is that you want me to know about your bond. I would simply caution you, if you don't make any statements about the underlying facts of this case, because we're recording this and it could be used against you later. Is there anything else that you want me to know about bond?
Well, I have no money because I went to prison once already and it destroyed my life and I have no way of working, so I have no money. So that should be taken into consideration. I'm pregnant, so I'm going to need OBGYN care. And when I left the hospital just recently, I told them, please make my appointment for the next day when I get discharged, because I cannot wait that long without seeing someone. I go crazy in the public because I have been to prison and I don't understand people anymore. And they didn't do that. So I went nuts because I found out I was pregnant. So all of that needs to be taken into consideration. $10,000 isn't too bad, but I'm not going to be able to make bond. So it doesn't matter. You're going to keep me in jail and probably send me to prison for this anyway.
Have you been to see a doctor yet about your pregnancy?
No, it's too early to even get a positive pregnancy test.
Are you currently working with anybody from community mental health on your treatment?
Yes, I am. Dr. Gurman is my doctor, and
I'm supposed to be getting hooked up with ACT as well. They were gonna help me and like get a plate because I'm homeless. And because my parents have dementia, they don't understand that I'm homeless. They won't take me into their house. They keep calling the police on me because they don't recognize me anymore because I went to prison.
All right. So do you think it would be a good idea for you to start working with Dr. Gurman again?
Well, I have a complaint with CMH filed against him for not being fair and violating my rights. So I prefer a different doctor. I've mentioned that to the court once. That hasn't been respected at all. But I need to work with ACT and CMH because I have depression, anxiety, and I don't know.
All right. Are you taking any medication?
Anxiety.
All right. Thank you. Are you taking any medications right now?
No, I'm not because I'm pregnant and I want to make sure that it's not going to negatively affect this pregnancy. Even though you're going to take this child away from me. I'm not interested in hurting this child.
Good. I'm glad to hear that. All right.
Yes. It's probably best for me to stay in jail for as long as possible because I have nowhere to go. So when I get out, I'm going to go back to violating the law so I can come back to jail.
Well,
no, that's the fact, Larry. I went to prison. I cannot work. Nowhere will hire me. I have no money. I'm stealing food like an idiot.
Okay, I don't want you to go into that, please.
Well, I'm just saying, he's asking questions. I'm telling him what needs to be considered with my bond. A PR bond would be nice so I can go look for work and take care of a baby, but that's not going to happen. I'm realistic.
Thank you, Ms. Brink. That's all the information I need right now.
Are you going to set my bond?
I'm thinking about that right now. So yes, ma'am, I am.
Oh,
just give me a minute.
Sorry,
just
you
give me
didn't
a
say
minute.
anything, so.
No, that's all right. Yeah, I understand.
I'm half nuts too because I haven't seen her talk to my children that already exist in a very long time. So I can't help it. You know, I really can't. I don't even understand that I'm breaking the law. My parents are nuts. I'm getting no support out here.
Well, we're going to try to get somebody to come into the jail and help you with that. All right, we are going to set bond at $10,000, 10%, cash surety or 10%. The reason for that is her past history of violent behaviors, assault, and resisting and obstructing. There does need to be some amount of bond that protects the public. However, because she has a mental illness, it also needs to have some treatment part of that as well. So the requirements, Ms. Brink, are that you appear for any scheduled court dates, that you abide by the judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while released, that you immediately notify the court in writing of any change of address or telephone number. You may not use any alcohol, marijuana, or illegal controlled substances while out on bond. You must participate in a substance abuse testing or monitoring program through community corrections. And you must comply with all community mental health treatment programs. And that includes doctor's appointments and medication as prescribed. You also may not enter the Walmart in Gaylord and you must contact community corrections upon your release. You have any questions about the bond?
No,
Ms.
I'm
Brink?
not gonna be able to make one.
Well, I set it at a point, you'd have to post $1,000. If you are able to, then you need to do what CMH tells you to do. Deputy, I asked that you guys call CMH and ask if they can send somebody to the jail to evaluate her and see if they can get her on some prescription medication.
Yes, sir. Can we make an OB? Well, whatever. I'll just tell them and they'll work with me on that way.
All right, that's all for today. Thank you, Deputy.
Okay.
Hold on a second.
Chelsey Brink and Devin Hildebrandt, file 11-14050-DS.
Your Honor, Ms. Brink is currently lodged.
All right. Ms. Kraus, given that information, what would you like to do today?
Do we have any idea as to where or the length of time, Mr. Brown?
She is in the Otsego County Jail. She was lodged just a few days ago, if not late last week. I believe it's a $10,000 cash surety bond. Her indication is she is not going to be able to post.
I would indicate then, given that, we could potentially, so it doesn't fall off the docket, maybe potentially adjourn it out to December 12th. And if we have information that she's out sooner, we could renotice it.
So ordered. All right. Well, it looks like I forgot one case on Ms. Brink. We have, this is William Mason versus Chelsey Brink, 13-15199-DC. We learned previously from Mr. Brown, when he was present in a previous case with Ms. Brink, that Ms. Brink is still incarcerated. So having said that, it's unlikely she's going to be able to do anything today. Trying to remember what we did in the previous case with Ms. Brink.
I believe it was adjourned to December 12th.
Yeah, let's do that. Keep them both together. That's about all we're going to be able to do today while she's incarcerated. This is the state of Michigan versus Chelsey Brink, file 25-44051-FY. Today is the date and time set for a felony status review. Mr. Brown, I believe this is your case. Is that correct?
That is correct, Judge.
Do we have a resolution of this matter?
I believe we actually do. I was speaking with Mr. Fortier. He has made a plea offer, which is essentially to plead to the retail fraud as charged. There are 2 felony counts of R&O. There is an offer to plead to 2 counts of attempted R&O. I did discuss that with Ms. Brink, and I believe she is going to take that offer.
All right. Mr. Fortier, I believe attempted resisting and obstructing would be a 1 year and or a $1,000 misdemeanor offense. Is that correct?
Correct.
All right. So Ms. Brink, as I understand it, the 2 assault or resisting and obstructing police officer offenses, which are felony offenses, would be reduced down to misdemeanor offenses. And then you would also be asked to plead to the retail fraud misdemeanor. And in exchange, the felony offenses for resisting and obstructing police would be dismissed, as well as the habitual offender would be dismissed. Is that your understanding of the agreement as well?
Yes, sir.
And is that what you want to do?
Yes, sir.
Have you had an adequate opportunity to speak with your lawyer about that?
Yes, sir.
All right. If you want to do that, you would be giving up your right to have a trial and all of the rights that you would have at trial. So let me inform you of those so you can make an informed decision. At a trial, you'd have the right to have a lawyer represent you. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own evidence and your own witnesses and get an order from the court requiring them to testify. You could also testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Knowing all of those rights, is it still your intent to enter your plea today?
Yes, sir.
All right, I'm going to have to take some testimony from you. So would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down. Other than this plea agreement that we've talked about today, has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right, let me start with the police officer charges. The new or amended charges would be attempted resisting and obstructing, a 1-year misdemeanor. And they would say that on or about September 21st of 2025 in the city of Gaylord and Otsego County, that you did attempt to assault, batter, wound, resist, or obstruct, or oppose, or endanger Officer Daniel Gertz and Officer Jacob Depew, police officers who you knew were performing their duties. Is that what you did?
Yes, sir.
Can you tell me what you did to those officers that was resisting and obstructing them?
I just didn't turn around when he asked me to, the first time he asked me to, and kind of I ran my mouth to him.
Well, typically attempted resisting and obstructing has to do something more than just talking. It's got to be some physical activity or some action that you took that either resisted them.
Right, that's what I'm saying. I didn't turn around.
Okay. Did you take some physical action either towards the officers or with the officers?
No.
Mr. Brown, is there any questions that you want to ask at this point?
Yes, Your Honor. Chelsey, do you remember being at the Walmart when the police showed up?
Yeah.
And you were there because I believe Walmart had called because of a potential theft, right?
Right.
And when the police were there, were they asking you to do certain things, giving you commands?
But he just said, after he questioned me about what happened, I have mental health problems, so I get sick sometimes, and I wasn't quite understanding what was going on. But anyways, he said that I was going to be arrested, and Depew asked me to turn around, and I said, I dare you. And so, like an idiot, he came at me and grabbed me by the arm, and I didn't move from where I was standing. I didn't assault him or anything like that. I just didn't help him arrest me. It's hard for me to agree to something so.
Did you tense up while they were trying to?
I probably will always resist because I don't agree with some of the laws,
Well,
so
Ms. Brink, they gave you a command. You did not immediately comply with that. When they were trying to arrest you, did you kind of resist by tensing your arms up so they could not do that?
Yes. Yeah.
Thank you.
Were
they in full uniform? You knew they were officers, correct?
Yes, I did. Yeah.
Okay, thank you.
All right. Any other factual basis questions that you have, Mr. Fortier?
No, Judge.
All right. As to count 1 and count 2, I do find that she's given me a proper factual basis. She's resisted the lawful arrest and the commands for the arrest by the police officers at Walmart in Otsego County on or about September 21st. Ms. Brink, as to count 3, which is the retail fraud, that reads that on or about September 21st of 2025, that you were in the Walmart store, which was open to the public, and you stole property of the store that was offered for sale at a price over $200, but less than $1,000. What did you do there?
You know, by the time I got to the door, actually, let me back up. I went in to use the bathroom, to be honest with you. Actually, let me back up even further. I drank a beer and I relapsed, and the day before, I spent the whole day.
Chelsey, I think what he's asking you is, did you take anything? I don't necessarily know if he needs the entire story. Did you take anything?
Yes, I did take
Yeah.
stuff. It was a baby seat and.
Ms. Brink, hang on a second. I'm going to give you a chance at sentencing to tell me all of the reasons why things happened. At the plea,
Okay.
I just need a small amount of information from you. So let me be specific. Sure. Did you go into the Walmart store when it was open to the public?
Yes, I did.
And that was on September 21st, right?
Yes, I did.
Did you steal property? Did you take without paying for certain property of the store?
Yes, I did, sir.
What were the items that you took without paying for?
A baby seat. I saw a baby seat, a backpack, and I think there was, from what I recall, there was a blanket and something else, nail clippers or something, and a backpack. Did I say that?
All right. And
I think that was it.
And all of that stuff, did it add up to a value of more than $200?
Probably, yeah. Yeah.
All right. Any other factual basis questions that either of the council have?
No, Judge.
No, Your Honor.
All right. And again, I find that Ms. Brink has given me a proper factual basis. She's admitted to stealing property of the store from Walmart that was open while Walmart was open, and the value was more than $200. Are either council aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor. And the court has complied with court rule.
All right. I will accept then the pleas as to all three of the charges. I do find them to be knowingly, intelligently, and voluntarily done, as she has properly answered my questions about promises, threats, or other inducements. Let me just make some notes. All right, Mr. Fortier, do we need to get some information from Walmart and give them an opportunity to be here for sentencing, or can we proceed today?
We can proceed today.
Mr. Brown, do you wish to proceed today?
Yes, Judge.
All right, Ms. Brink, what I'm going to do is I'm going to ask each of the lawyers what they think we should do for sentencing. And then I'm going to, after you've heard what they say, I'm going to give you a chance to tell me anything that you want me to know as well. So listen carefully. Mr. Fortier, your thoughts on sentencing?
Judge, after having an opportunity to review the video for this one, I think it was pretty clear there were some outside factors going on with Ms. Brink. Frankly, I think the court's well aware of kind of what's been going on with her history. I think an appropriate sentence would be giving her some jail time with credit for what she's already served, but then putting her on probation. I would leave up to the court. If she is going to be on probation, I would ask that she continue any sort of mental health treatment that she is undergoing or should be undergoing. I think CMH, if they're not already involved, should become involved. And to that extent, whatever treatment recommendations she has, I think she needs to follow through with. There is no restitution as well, as all items were recovered. And I had an opportunity to talk with both police officers that were involved, and they understand that there were additional factors outside of just what most people might think is going on. So they were okay with the attempts.
Mr. Brown, allocution.
Thank you, Your Honor. I would largely echo what Mr. Fortier said. I am not going to rehash her history on the record. The court is very well aware of it. All I'm going to do is ask the court to fashion a sentence which primarily deals with her mental health, which is, I think, what should be the focus. Obviously, there is an element of punishment. She has been sitting for quite a while, but I want her to get the help that she needs. Thank you.
All right. Ms. Brink, this is your opportunity to tell me anything that you want me to know about you and about what you think the sentence should be. So if you have any comments, this is now the time to make them.
Sure. Mostly I just want you to know that I did relapse and drink a beer after being sober for about almost a year now. And so that negatively affected me. I spent an entire day trying to sober up. I had not taken my medication that day. Sometimes I'm usually pretty good about it, but I don't know what happened. I'm homeless and I've been living in my vehicle. It's very lonely being homeless. And you know, I've got mental health problems, and so I don't always 100% understand what's going on, to be honest. So I just want the court to understand those things, and I appreciate Mr. Fortier being so kind with his words about what's, about what you think I should be sentenced to. Larry Brown did a great job, in my opinion, representing me. And I'm embarrassed mostly, and so it's even hard to even verbalize how I feel right now and what I want you to know. And I'm ashamed of myself because I didn't think I would, after prison, I didn't think I would end up in this position again. And so I feel horrible, and I fucked up. Excuse my language, but that's the truth of it. And my parents are ashamed of me and embarrassed of me. And so that's enough punishment for me, to be honest. But I know you have to impose a sentence. And so if you can just give me work camp or probation or something minor, I don't know, because even if they let me out of jail, I don't know where I'm going to stay yet. So just take those things into consideration, I guess, if you can.
All right. Well, Ms. Brink, I want to say thank you for the work that you've done to get yourself back together with your mental health treatment. There's a world of difference between today and some of the previous conversations that we've had. And I want to say you're doing much better today. And I appreciate that. You're a thoughtful person today. And I think that bodes well for if you stay on your medication and stay on your treatment plan, things can go much better for you. But
yes,
that's
sir.
kind of where,
when I was in prison and even slightly before that, I wasn't working with CMH right away, but they messed with my meds a lot, and it got me all kinds of confused because they would change it a lot. While I was in prison, they changed my medications a lot. I had some seizures. I hit my head a couple times. But when I got out of prison, since then working with CMH, they've changed my medication so much, and so it's very hard to understand what's happened from then until now without getting outside person's opinions, because or facts even, really, because I know I've been in the hospital a lot. I can tell you that, and been in jail a lot, but I don't they just change it, and so the shot of Abilify works pretty good. And so does the Zoloft and gabapentin. I need to get back on metoprolol for my AFib. I know that, and the jail's working with me on that too, so that's good.
okay.
But
Well, I'm just simply going to say that the doctors are the ones that control all that kind of stuff. They're the ones that, and sometimes they have to experiment and see what works best for you. But I'm going to require you to do that, to work with them. So
yes.
Let me ask you just one other small question before I tell you what the sentence is going to be. How much time have you been in jail now, up to this point?
I believe a month. Monday will make a month.
All right, so at least 25 days?
Yes, sir.
All
I
right,
believe so anyway. Today's, I don't even know the day of the week. Thursday, I think. Today is.
yes, today is Friday.
So, oh, today's Friday.
Today is
Okay.
Friday the
So,
17th. Have you been in jail for all of October and part of
Yes.
September? All right,
yes, sir.
okay,
Since the 22nd of September, I've been in jail.
all right. I'm gonna put you on probation for 6 months, just so we can make sure that you're doing what you're supposed to be doing with your medications and with your treatment.
Right. Yep.
There's a cost for that. There's a $75 mandatory crime victim rights fee, a $50 justice assessment. I'm going to reduce I got 3 charges I got to do things on, so bear with me for just a
You're right.
minute.
Yes, sir.
I'm going to reduce the court costs to $100 on each one of them. And I'm going to reduce the fine to $50 on each one of them. And then there's a $180 probation oversight fee on each one of them as well. So let me add up those amounts. It's a total of $770, and you can pay that over the course of probation.
Okay. Over the course of 6 months, then.
Yep, yep.
Okay. Thank you.
I'm gonna let you do community service work if you can't find work right away, so that you can work that off at the discretion of the probation office. There are some fines that you have to pay yourself, but you can enroll in some of them. I'm going to require you to go to CMH, Community Mental Health, and follow all recommendations and submit a release to probation so that they can know what you're supposed to be doing with community mental health and what your treatment program is. All right?
Yes, sir.
So take all your medications, go to counseling, whatever they tell you to do, that's what you're going to have to do.
Right.
No consumption of alcohol or non-prescribed drugs. That means if your doctor tells you to take a drug, then you take it, but you can't take street drugs and you can't abuse your prescriptions. You understand what I mean by that?
Yes, sir. Yes, sir.
I don't want you to go to any bars or places where alcohol is served by the glass. So stay out of there. That way, because if you're mixing your medications with alcohol, bad things happen.
Yes, I know. Yes, I know.
All right. I am going to send you, because you're not working right now, I am going to send you to the work camp for 10 days so that you can give back to the community. That'll make you feel a little bit better about yourself too, once you get out and you're able to do something. And hopefully that'll give you a little bit of structure so that you know where you're supposed to be and when you're supposed to be there.
Okay.
Mr. Fortier, are you aware whether or not the United Way still deals with people that have housing issues?
I do not know.
Mr. Brown, are you aware of any other agency in the community that deals with housing issues that could help her find some place to land?
Unfortunately, no. I don't know if NEMSCA deals with those things or not.
There used to be an agency called First Call for Help that had a way of doing the phone tree and calling places like that. I'm going to ask probation to contact community mental health and help her deal with the homeless issue, or at least make some referrals, see what is out there.
Because I don't know where I'm going to live, is it okay if I ask when I'm getting out of jail? Like, is that happening today? Because I'm a little bit nervous about that. I have nowhere to go.
Should I just try United Way when I get out and see if they'll put me up somewhere or something?
Yeah, I'm gonna ask our probation department if they know of any other community resource that deals with homelessness. I don't know that we have a specific shelter in town anymore. We used to, but I don't think we have one now. But I believe that DHHS may have some funding available for emergency bases.
Okay.
And I'll ask our probation department to call and see if there's anything that they can point you to when you are released. I'm going to give you 25 days in jail, credit for 25 days.
Great.
So you don't
Thank you,
have to serve, you don't have to serve any additional jail time, but you will have to go to the work camp. And so you're going to need to contact them to get that set up and get started with that once you are released. And I'm going to ask probation to try to see if there's any place that we can put you, or that at least you can go and make an application for a place to stay. I can't guarantee anything, but we'll at least work with you and try to help you that way. Are there any other questions that you have, Ms. Brink?
No, sir. That is all.
Mr. Brown?
No, Your Honor, thank you.
Mr. Fortier?
No, Judge.
All right, good luck to you, ma'am. Please, for everybody's sake, stay on your medication and do your counseling like you're supposed to, okay?
Yes, sir, I will.
All right, good luck
Thank
to
you
you.
so much. Yes, thank you. Thanks, Larry.
4 weeks later.
Are you Chelsey Brink? I have to hear from you, ma'am.
Yeah.
All right, thank you. I'm Judge Hesselink. I'm coming to you from the district court. You're here today because of an arraignment. There's actually two files, a new file and a probation file. Let me call those cases. The first one is the State of Michigan versus Chelsey Brink, file 25-44174-FY-3. That is set for a new arraignment. And we're also here today on State of Michigan versus Chelsey Brink, file 25-44051-F3. That's a probation violation file. Let me turn to the first new file. With me today to assist in that is Richard Trush, defense counsel, and Mr. Fortier from the prosecutor's office. The new charge against you reads as follows. It says that on or about November the 18th of 2025 in the city of Gaylord, Otsego County, in count 1, you did commit the offense known as police officer assault, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Colton Huff, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is would normally be a felony offense with a 2-year and or $2,000 fine. However, you've also been charged as a habitual offender fourth offense notice, which has the effect of enhancing the sentence. That notice says that you were previously convicted of 3 or more felonies or attempt to commit felonies. In that on or about October the 13th of 2020, you were convicted of the offense of police officer assaulting, resisting, or obstructing in the 46th Circuit Court for Otsego County in the state of Michigan. On February the 5th of 2019, you were convicted of the offense of attempted arson, preparation to burn in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about February the 8th of 2018, you were convicted of the offense of felony kidnapping, custodial interference in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, there is an enhanced penalty, and because the underlying offense has a penalty of less than 5 years, the new penalty would be up to 15 years in prison. Do you understand the name of count 1 to be police officer assaulting, resisting, and obstructing?
Yeah.
Do you understand the maximum penalty under the habitual fourth offense notice for that charge is now up to 15 years in prison? I'm sorry, I have to hear something from you, either yes or no, ma'am. I'm sorry, I was not able to hear you. Thank you for making it a little bit louder. Count 2 reads as follows. It's entitled police officer assaulting, resisting, or obstructing. It says that on that same date and time, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Depew, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. Again, that would normally be a felony offense of 2 years and or $2,000 fine. However, you have also been charged with the habitual offender fourth offense notice that I just read to you on as to count 1. That now applies to count 2 to make that a felony offense with a maximum possible penalty of 15 years in prison. Do you understand the name of count 2?
Yeah.
Do you understand the maximum penalty for count 2?
Yeah.
All right. Count 3 is the name of that offense is Mail and Mail Depository Protection Act, also involving mail theft. It says that on that same date, time, and place that you did take, hold, conceal, or destroy mail addressed to another person, that is Lisa's Tavern, with the intent to deprive that person to whom the mail was addressed of the mail, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 1 year and or a $500 fine. Do you understand the name of count 3?
Yeah.
Do you understand the maximum penalty for count 3?
Yeah.
The final count, count 4, reads as follows. It says that on that same date, time, and place that you did commit the offense known as trespass, in that you did remain without lawful authority to remain on the lands or premises of Lisa's Tavern after being notified to depart therefrom by Elizabeth Arndt, who was the agent of the occupant of the lands or premises, contrary to Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 30 days and or a $250 fine. You understand the name of count 4?
What is it?
It's called trespass.
Oh, yeah.
You understand the maximum penalty of 30 days and or up to $250 fine?
Yeah.
All right. You have certain rights, and I want to make sure that you understand those rights so you can decide what to do with them in the future. Your basic rights are you have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or a jury. At that trial, you would also have trial rights, which include the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could remain silent, and if you chose to remain silent, that silence could not be used against you. At trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you have any questions about any of those rights?
No.
Do you believe that you understand those rights?
Yes.
All right. Mr. Trush, as to her right to an attorney, have you had a chance to speak with her about that?
I did, Your Honor. She has been screened and qualifies for counsel. Again, traditionally, I think she's been represented by Mr. Brown. I expect he'll be appointed in this matter as well.
All right. Ms. Brink, until you have a chance to speak, with your attorney, I'm going to enter a not guilty plea on your behalf in order to protect your rights. Because you've been charged with felony offenses, I'm also going to set some quick court dates to also protect your rights. The first date is called a probable cause conference. That'll happen in the next 7 days. That's a chance for your lawyer and the prosecutor to speak to see if they can resolve the case quickly. In addition to that, within the next 21 days, we'll set a preliminary examination date. Now, that's a short hearing in district court in front of me as the judge to determine whether or not the prosecutor can show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It is simply a check to make sure that there's sufficient evidence to proceed with the case. Do you have any questions about those 2 court hearings?
No.
All right. What we're going to do next is address the issue of bond. So I'm going to listen to both of the attorneys, and then I'm also going to give you an opportunity to tell me what it is that you want me to know before we make that decision. Mr. Fortier, as to bond.
Your Honor, I did submit a bond recommendation form. In it, I want to note that she is on probation currently in case 2544051-FY, where she was sentenced to 6 months probation on a retail fraud second degree and 2 counts of attempted resisting and obstructing a police officer. She was sentenced on October 17th, 2025, so just about a little over a month ago. I think based on the fact that she was out on probation for an assaultive offense, she's got assaultive offenses in her criminal history. She does present as a risk to the community at large. The court's obviously well aware of issues that Ms. Brink has. She's continuously picking up trespassing and R&O charges when the police are called. So based on that, I think a bond amount of $10,000 cash or surety would be adequate. I would also ask that, in addition to the standard conditions of bond, that the court order no drugs or alcohol be consumed, along with no marijuana, and that she participate in a substance abuse testing or monitoring program at the discretion of community corrections. Ask that she would report via community corrections, and that she participate in a specified treatment program, specifically with community mental health. I know she had indicated prior circumstances that she was involved with them. However, I'm not sure the extent of that involvement right now. I think it needs to continue, or at least be essentially restarted if it's not happening. I would also ask that she have no contact with Lisa's Tavern, that she not re-enter Lisa's Tavern, and that because she is charged with an assaultive crime, on top of the fact that she's got felony criminal history, that she not possess any weapons or firearms. And that's it.
All right. Mr. Trush, your thoughts?
Thank you, Your Honor. In regards to the bond on this matter, a few things that I think are important. Given the circumstances, we expect some amount of cash bond is going to be put in place here. I would indicate Ms. Brink has substantial connections to the community. She's essentially lived her entire life in Otsego County. I think the court is familiar with some of her economic circumstances. She reports that she's homeless. I know that she has reported that to the court consistently, I think, in other hearings, which I wasn't a party to, but happened to be present and observe. She reports that she struggled to get a job since being released from prison, with a felony on her record. She reports that it's disqualified her from a lot of jobs. She reports that she's always appeared. And again, I would just indicate to the court, I think that some cash bond is surely going to be put in place here. $10,000 seems high. I would suggest to the court a $5,000 bond is more appropriate. And I would suggest to the court, again, the court I think is aware of some of her other economic issues, and frankly, the fact that she has some other matters, which frankly, if she had available funds, I think would be more appropriately put to those than to a bond here. Thank you.
Ms. Brink, you do have the right to address me as to anything that you think would be important for bond. I would simply caution you that not to make any statements about the underlying facts of the case, because we are recording this and it could be used against you later. But if there's anything that you want me to be aware of, I'd be happy to listen to that now.
I'll stand mute.
All right, thank you. All right, I do note, as the prosecutor indicated, that Ms. Brink has just recently been sentenced on a case that involved, at least in part, resisting and obstructing or attempted resisting and obstructing police officers on the same offenses that she's now alleged to have committed on this particular case. She was on probation at the time she was alleged to have committed these charges. That she has ties to the community, but she has indicated to me in not only that previous sentencing, but in the other cases that she's been involved with the court, that she is homeless. I believe that she sold her home that she had here in Otsego County a couple of years ago and used that money basically to stay in hotels for a little less than a year. She has not, to the best of my knowledge, had any long-time employment, if any employment at all, in the last year or so. So while she is well known to the court system, she has very limited things that tie her to this community, other than the fact that she may have people that she knows in the area. So because of her inability to keep herself out of trouble and the fact that she is being violent towards our police officers, I believe that a cash bond of $10,000 cash and surety is appropriate in this case. Conditions of release on that bond include personally appearing for all court dates set by the court, abiding by any judgment of the court, not leaving the state of Michigan without prior permission of the court, not committing any crime while on release, and immediately notifying the court in writing of any change of address or telephone number. She must also not use alcohol, marijuana, or any illegal controlled substances while out on bond. She must participate in a substance abuse testing or monitoring program through community corrections. She must participate in a specified treatment program for any physical or mental condition, including substance abuse, and that was specifically would be community mental health, and follow all recommendations of that assessment. She may not, because of her danger to the others in the community, she may not purchase or possess a firearm or other dangerous weapon while out on bond. She may not have any contact with, direct or indirect, with Lisa's Tavern. That means she may not call it, she may not show up in person, she may not use the internet or social media. No contact means no contact. Finally, she may not enter Lisa's Tavern in Gaylord as well. And then upon her release, she must contact community corrections within 24 hours of her release so that they may monitor her while she's on bond. Ms. Brink, do you have any questions about those bond conditions?
No.
Mr. Truce, anything?
No, Your Honor, thank you.
Mr. Fortier, anything else?
No, Your Honor.
All right, Ms. Brink, we also have one additional matter. Before I forget, Deputy, could you make sure that Ms. Brink gets fingerprinted on this new charges as well?
Yes, Your Honor.
Thank you very much. All right, Ms. Brink, we also have a probation violation issue. The allegations made against you on that is that you were charged with a new criminal offense of larceny, resisting, obstructing, and aggravated assault on 11/18 of 2025. That's the charges that I just read to you. Well, I'm not sure if that's exactly the way it should be read, but you've also been charged with police officer resisting and obstructing, and trespassing, and mail theft. The recommendation is that you serve 93 days in jail and that you be discharged from probation with fines and costs preserved. Do you understand the nature of the allegation made against you?
Yeah.
Do you understand the recommendation as to what would happen if you were to admit or be found guilty of that?
Yeah.
All right. I'm going to assume that you wish to have an attorney represent you on that matter as well. Is that correct?
Yeah.
All right. And I will, because I've just heard that you have qualified for court-appointed counsel, I will appoint court-appointed counsel or send that to Mr. Gilo to determine who should be your lawyer in that. I'm going to enter a not guilty plea on your behalf until you have an opportunity to speak with your lawyer about that. And then we're going to set a court date in conjunction with your new felony offense so that they're both heard at the same time. I don't know what that date's going to be yet, but we'll have that done for you. And we'll send the notice to you at the jail or at the address that you give us as to where you want mail sent to. Where would you like to have notices and mail sent to, Ms. Brink?
I'm in jail. What do you mean?
If you get out, obviously, if you're in jail,
I'm not
we'll
going
send
to
it
get
to you
out.
there.
I'm homeless. I have no job and I'm homeless. I'm not getting out.
All right. Does that mean that you don't want to have a mailing address to where you can pick it up from
Right.
somebody else?
Right. I got no mailing address.
All right. So we'll send the notice to you at the jail. Do you have any questions about that?
No.
All right. That's all for today then. Thank you very much. You're free to go. All right. Do we still have Ms. Brink at the jail? Is Chelsey Brink at the jail?
Yes, sir.
All right, thank you, Ms. Brink. I do see Mr. Brown, Ms. Hansel, Ms. Bruker are back from meeting with Judge Cooper in his courtroom. So let me call the Brink case This is the matter of the state of Michigan versus Chelsey Brink, file 23-10800-MI. Petition for continuing mental health treatment order. Ms. Bruker, how do you wish to proceed today?
We can start with testimony, Judge. I see Dr. Gehrman is here and Mr. DeMarsh is here as well.
Your Honor, I
Like
don't think I got
Before we
notice.
proceed, I would like to say that I do not want Larry Brown speaking and only Donna Hansel to be representing me. And I would just like to proceed with a guardian, and I'd like to name Jason Winowicki as my guardian for my mental health services. I've already said that once. I meant it.
Okay, Ms. Brink, I can't see you at the moment. Could you stand up so I can see you a little, please?
You had no problem seeing me a moment ago, but sure. So you can look at my breasts, is that it?
Ms. Brink, I appreciate it if you confine your comments to appropriate statements.
That is an appropriate statement. You forced me to do something I didn't want to do. You said you could see me and hear me.
Ms. Brink, step back. Step back right now. Step back against the door.
I did step back.
Thank you,
How about
Deputy.
you step back and get out of my personal space? This is my court hearing. You're a pig.
Ms. Brink, this is a court hearing, so you will conduct yourself as if it is a court hearing, which means you speak when it's your turn and you don't call people names.
I let you speak, and then I said before we begin, and you said go ahead and proceed. I heard you say it.
Ms. Brink,
No, we haven't broken court law.
it's not your turn right now. All right.
Not now, it isn't.
Ms. Bruker, who do you want to testify first?
Dr. Gehrman.
Dr. Gehrman, can I
Who's not my
swear you in
doctor?
if you'd raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you.
Just let me know if you need me to.
Sir, can you state your name
Go
for the
ahead, please.
record and spell your last name?
John D. German. Gherman.
Okay. What is your occupation?
I'm an adult psychiatrist.
Okay. And do you have some training and other types of certificates in order to hold that position?
I have a research fellowship, clinical fellowship of 1 year in psychosis and schizophrenia.
Okay. And is a large portion of your practice dedicated to the field of psychiatry?
All of it.
Okay. Are you familiar with someone named Chelsey Brink?
Yes.
And did you conduct an examination of her recently?
Recently and several times before, yes.
Okay. When did you most recently see her?
November 13th from 10:40 a.m. until 11:12 a.m.
Okay. And where did that examination take place?
It was through telepsychiatry, Doxy, in Gaylord, Michigan.
Okay.
The Gaylord, Michigan, Otsego jail, I guess.
And you said you've examined her in the past?
It was in Gaylord office.
Okay. And you said you had examined her in the past?
Yes, I have.
And did you also review some of her past records as well?
I always do.
Okay. Do you believe that, does Miss Brink have a diagnosis?
Yes, she does.
And what is that diagnosis?
Schizoaffective disorder, bipolar type, and post-traumatic stress disorder. And I also suspect personality unspecified with antisocial traits, if not the entire antisocial personality disorder as well.
Okay. Do you believe that she's a person requiring treatment under the mental health code?
Yes.
Okay. And what do you base that diagnosis on? What observations and or opinions do you base that on?
Evals and medical record, her past history of deviant behaviors and labile moods and psychosis.
Okay. How did Miss Brink present to you during your most recent examination of her?
She was irritable and had a thought process disorder, form of thought disorder, at times just nonsensical and perseverating over minutia. And
You understand that you proceeded on a court hearing without my legal representative?
Ms. Brink, this is not your time to talk.
It's my court hearing. It's about my mental health, therefore it's about my medical record, therefore it's about.
And just like loud and easily agitated. And she did reveal she had partial insight at the time that she has a history of chronic ideation and attempts and wanting to walk into traffic. But she had minimal insight whatsoever regarding her diagnosis or condition, excepting the condition that she suffers from bipolar spectrum / schizoaffective disorder.
Okay. Did you discuss with her any treatment plan and whether she would be compliant with the treatment plan?
Yes, yes, I have. I always, we've done that before. She's on the long-acting injectable, and she should remain on that. But she should also she needs to take the oral medications as well. But the long-acting injectable is crucial. Without that long injectable, she will degenerate. There will be progressive brain atrophy. There will be a risk of incarceration. There she is. There's a risk of high behaviors, and she has that. There's a risk of homelessness, and I think she's been homeless before. So there's a risk of substance use disorder, alcoholism. So without that LAI, that long-acting injectable in treatment, there's risks for the above. Significant risks.
Did she express any willingness to participate in her treatment plan voluntarily?
No. Yes, she did. She does not want to participate. Meds don't do much for me.
Is that what she said?
Yes.
Okay. Do you believe that she has a difficulty with attending to her basic physical needs as a result of her mental illness?
The difficulty is there when she's in a psychotic manic state, as she is now. That's the difficulty. Otherwise, if she's properly adequately treated and interepisodic, I don't see a problem. She should be fine with basic needs. But she has to we have to avoid these episodes.
Okay. Are you recommending hospitalization or outpatient treatment?
She's in jail right now, so I'm not recommending anything. She's safe in jail, but I recommend AOD and to continue the involuntary treatment or the ACT, a sort of a community.
Okay.
Ms. Bruker, I'm sorry, doctor. Let me interrupt for just one moment. If we could unmute the jail for just a minute.
Your Honor?
Deputy, yes, I noticed that Ms. Brink left the area where she was being recorded. Could you tell me what happened there, please?
Yes, sir. She's in here kicking the Polycom. She's getting very upset at what she's hearing. Her emotions are getting out of control. And with her kicking the Polycom, I put her back in the max cell as of right now. So.
All right.
She kicked the door at least. Yes, sir.
Yeah, I appreciate what you did. Thank you very much for doing that. I'm probably going to ask you in a minute or two if she has settled down. If you could go check if she's settled down. I'd like to bring her back and have her available to answer some questions of, or at least make a statement to me about what she wants to have done. But for now, thank you very much for that update. So Ms. Bruker, go ahead and continue with the doctor. Sorry about the interruption.
Dr. Gehrman, you completed the clinical certificate that outlined the results of your examination. Is that correct?
Yes.
And on it, it looks like under number 4, you checked that you're recommending a combination of hospitalization and assisted outpatient treatment up to a year AOT. Is that correct?
Yes.
Okay. Is there anything else regarding Ms. Brink that you'd like to inform the court of?
No.
Okay. I don't have any other questions for him.
Thank you. Mr. Brown, are you still with us?
I am, Your Honor.
Any questions for this witness, Mr. Brown?
No, Your Honor.
Ms. Hansel, any questions for this witness?
Yes, sir. It's my understanding, doctor, that if Miss Brink were taking her injectable appropriately and then her oral medications appropriately, it's your belief that she could function on a normal basis or close to that?
Yes, the problem is she never seems to be around to be on that inadequate amount of time because she always has partial breakthrough symptoms also.
Okay. And do you believe, I think I'm understanding your report, but do you believe that if she does not take these medications, that she would be a threat or of harm to herself or to other people?
Well, she said herself, she's always thinking about walking into traffic, Ms. Hansel, and she's made threats, if I'm not mistaken, verbal threats, serious threats to the director of ACT. Okay. And what don't you understand about the report, if I may ask?
To tell you the truth, I was having a little bit of problem reading your handwriting, and I'm not a medical person, so I think I understood it, but it's I just wanted a couple of things clarified.
Okay, ask.
Okay, all right. So do you believe, okay, you mentioned hospital.
In the middle of the page, if you can see bipolar, question mark, no insight. Schizophrenia, no.
Okay.
Meds don't do much for me. Ideation, yes. Walking into traffic, those are the pertinent ones.
Okay, I understand. Do you believe that hospitalization should be that should be something that's looked at right now, like she needs to have that immediately, or can you tell?
Actually, seeing her right now, the way she's presenting right now, yes, I think she should be hospitalized or carefully observed there, perhaps even put on 15-minute watch or a watch for suicidality.
Okay.
Honestly.
Okay. Have you had a long time relationship with her? Like, have you been seeing her over a matter of years, or do you know?
I've seen her since April of 2024. Once, twice, 3, 4. 4 times.
Okay.
For med reviews in ACT. And also a couple of times such hearings as this. But she's also refused to see me a couple of times as well. She was uncooperative, so at least 6 times. 6 attempts, 4 times, 2 other attempts.
So do you believe at this point in time, if she's demanding a trial, do you believe she'd be competent to be in a trial? Would she be competent enough that she could assist her attorney in representing her?
About though, right?
Pardon me, I'm sorry.
This hearing is not about the competency though, is it?
No, I'm just her lawyer, and I'm trying to line this up with whatever is in her best interest. So
I'm not sure I would reval her, you know.
Okay.
Need a
All right.
thorough psychological exam as well.
Okay. All right. Thank you very much. That's all I have for now.
Ms. Bruker, any follow-up questions with the doctor?
Not for Dr. Gehrman, no.
All right. Thank you, doctor. Appreciate your time. That's all for today. Ms. Bruker, any other witnesses?
Can I just briefly call Mr. DeMarsh?
Mr. DeMarsh, can I have you raise your right hand? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. Thank you very much. Could you state your full name for the record? And then Ms. Bruker has some questions for you.
Ryan DeMarsh.
And Mr. DeMarsh, what's your occupation?
I am the supervisor of assertive community treatment for North Country Community Mental Health.
Are you familiar with Chelsey Brink?
Yes, ma'am.
And did you file this petition for continuing mental health treatment?
Yes, ma'am.
Okay. And have you met with Miss Brink in the past? Are you familiar with her?
Yes, ma'am.
Okay. And why did you file this petition? What facts or observations led you to do that?
I filed 3 notifications of noncompliance in the last 6 months due to missed appointments and or missed appointments basically. And so basically she hasn't been able to be compliant with her treatment order as it is. So
Okay.
a continuation made most sense to me. Yeah.
Okay. So she has not been taking her medication, following through with any of the services that you've been offering?
Her medication has been administered. It's an injectable. The weekly counseling and contacts that we have been attempting to have with her to help her with homelessness, to help her find a place to live, to basically help her stabilize, she has actively avoided any type of outpatient help. She did come for her injection because she knew if she didn't, that the police would pick her up, and the police did bring her in for that injection.
Just based on your experience with her and your observations, is Ms. Brink able to care for herself?
Absolutely not.
Okay. And why do you say that?
As I just said, she's unable to recognize the need for treatment, inability to even participate in her own care for like applications to Social Security, applications for state benefits, applications for there's a lot. She's actively avoiding help.
Okay. And do you agree with Dr. Gehrman's recommendation of combined hospitalization and assistant outpatient treatment order for up to a year?
100%.
Okay. And do you know where her hospitalization would occur if that is what occurs?
Well, the way it works at this point is while she's in jail, it's not likely to happen. But should she be released for some reason and she has some psychiatric episode in the community, she would be taken to OMH or whatever the nearest emergency department is, screened for her appropriateness for psychiatric hospitalization. And then the first bed that is found, whichever psychiatric hospital within the state of Michigan that is, that's how that process goes. She is also on the state psychiatric hospital list, but she hasn't been called for that yet. She's been on that for approximately 6 months.
Okay. Anything else you'd like to inform the court of?
No, ma'am.
All right. I don't have any other questions for you.
Thank you.
Ms. Hansel, do you have any questions for this witness?
Yes, I do. I do apologize. I'm not familiar with a lot of stuff here. But what exactly is this list that you're referring to?
So there's a Michigan state hospital list for people that are in need for long-term psychiatric hospital care. And the list is extraordinarily long because there are many people within the state of Michigan that are on it, and we really have no power in pushing it up. The state of Michigan determines who comes in when they go and when they don't. And typically the people that get into those hospitals are found not guilty by reason of insanity.
Okay. Okay. So there are facilities, but they're just too overcrowded, or they're just too many applicants to
Yes, ma'am.
get her in. So only the most severe cases are getting into that.
Well, and it looks like, given what's going on the other side of our court problems, that maybe that's an option. But today we're talking about the AOT, I believe.
Yes.
Yeah.
Okay. Do you have any knowledge of, well, you said she's getting the injectables. Is that, is she routinely getting those, or is that very sporadic and
It's been sporadic.
only
It's
when
when
you
we
can-
can locate her. She moved to Flint for a period of time. She's moved about to Petoskey for a period of time. Like I said, she is actively avoiding mental health treatment.
Okay. I have no other questions. Thank you.
Mr. DeMarsh, as a proposed order, I've included that she comply with her individualized treatment plan, and that she attend all appointments and take medications as prescribed. I'm trying to think of language or verbiage that would assist in the non-compliance notices. Is there any other specific language that you would ask the court to use to assist you in helping her get her treatment as needed?
You know, I'm not sure, Your Honor. I'd be happy to discuss it at some point with the court, but at this point, I'm not sure what we can add to that. The person herself is actively avoiding treatment, so I don't know that the language of the order itself can really do anything. I'm not sure, Your Honor.
All right. I just want to make sure that I was
Yeah.
covering everything that possibly
I get
could
it. I understand.
at
Thank
this
you.
moment. So if you do come up with some additional language that you want to have included in some of these in the future, feel free to send them to me. I appreciate that. All
Yes,
right.
sir.
I don't have any other questions. Thank you, Mr. DeMarsh. Ms. Brucker, any other witnesses that you have?
No, Your Honor.
Ms. Hansel, are there any witnesses or evidence that you want to have? And I'll bring your client back in just a minute to see if she's going to be able to continue to participate with us.
Thank you. I have no other witnesses, Your Honor. No.
All right, if we could unmute the jail again. Deputy, is there someone there at the jail that we can speak to?
Yes, Your Honor.
All right, thank you, Deputy. Have you had a chance to see whether or not Ms. Brink has settled down at all?
I let my partner ask her. She escalated again. If you would like for the court, I will ask one more time.
I'd like to have her say whatever she wants to say, but I want to make sure that she's safe and that you are safe when she's doing that. So if you could ask her, tell her that the court wants to hear from her, but she has to calm herself down in order to do that, and then bring her in if she's able to calm herself down, please.
Yes, Your Honor.
Thank you.
Your Honor.
Yes.
Your Honor. She's making demands to where she don't want to be interrupted or asked anything. And she's just escalating from 0 to 100 right now. So that's
right.
where we're at. We're not gonna, I'm not bringing her in here. So
All right, I appreciate that. I just wanted to give her that opportunity, and I do appreciate your attempt to help me with that. And again, I want to make sure that everybody's safe there, and I don't think she would be at this point. So I agree with your assessment. So thank you very much.
All right, sir.
You're welcome. All right. Ms. Brucker, is there anything else, any closing argument that you wish to make?
Other than I just asked the court to grant the relief that's been requested.
All right. Ms. Hansel, any argument that you have?
Just to advise the court, I did have contact with her yesterday.
Yeah.
And she was verbally very combative and insisted on having a trial. So that was where we left it, is that she wanted a trial. And she doesn't feel that she needs the assistance of the court or any type of mental health assistance. She thinks she's doing fine. And she regrets that she ever had agreed at some point in time. Apparently, she agreed for services at some point in time. She regrets doing that. So I don't have, I don't have any plan here, Your Honor. So I would appreciate any direction from the court as well. I certainly will attempt to represent her as best as I can, but she became combative and very verbally derogatory toward me.
Thank you, Ms. Hansel. I think your representation of Ms. Brink was fine. Ms. Brink has a history with the court of being exactly how you saw her today and exactly as how you saw her yesterday. And that is likely as a result of her mental illness, which is uncontrolled or not sufficiently controlled at this time. So the court will find that proper notice was given. Ms. Brink was given an opportunity to be here, that the hearing was held without a jury because it was not specifically requested ahead of time and properly requested. She was represented by counsel. We heard the testimony of Dr. Gearman as well as of Mr. DeMarche. And there's clear and convincing evidence that Ms. Brink is a person requiring treatment because she has a mental illness and her judgment is so impaired by that mental illness that she lacks the understanding of the need for treatment. And that causes her to demonstrate an unwillingness to voluntarily participate in or adhere to that treatment, which is necessary and on the basis of competent clinical opinion of Dr. Gearman to prevent relapse or harmful deterioration of her condition. And she presents a substantial risk of significant physical harm to herself or to others based on her ideation and her refusal to engage in proper treatment and her then combativeness, which was very clearly evident even in court today, and her unwillingness to cooperate with jail staff by trying to damage the Polycom equipment and then escalating every time she was given an opportunity to come back into the courtroom. So it's very clear to me that she is a person requiring treatment and that we will enter an order that she receive a combined hospitalization and assisted outpatient treatment for up to 365 days with initial hospitalization up to 60 days. She receive assisted outpatient treatment for no longer than a year and that be supervised by North Country Community Mental Health and include all services recommended by the treatment provider, including medications, injectables, and dissolvables, blood and urinalysis testing to determine compliance and effectiveness of medication, individual therapy, assertive community treatment services, and any other services necessary to assist her in her individual living and functioning in the community, including complying with individualized treatment plan, mental health provider as deemed clinically appropriate, attend all appointments and take medications as prescribed. If she refuses to comply with psychiatrist's order for hospitalization, a peace officer may take her into protective custody for that purpose. And I will sign that order today. Thank you all very much. That will conclude today's hearing.
Thank you.
Thank you.
All right, I do see that Ms. Brink is with us at the county jail. We'll call her matters next. This is the State of Michigan versus Chelsey Brink, file 25-44051-FY. And we also have Chelsey Brink, State of Michigan versus Chelsey Brink, file 25-44174-FY. Mr. Brown is back. Let's see, we have a response from the Center for Forensic Psychiatry in file 44174, but I believe this is as to both files. Is that correct, Mr. Brown?
I believe so, Your Honor. One is a probation violation.
All right, that is true. I see that now. Mr. Brown, I've received a copy of the report from the Center for Forensic Psychiatry dated January the 29th of 2026. Have you received a copy of that as well?
I have, Your Honor, and I did attempt to go over that with Ms. Brink a couple days ago.
All right. Mr. Fortier, have you received a copy as well?
I have.
Mr. Brown, as to Ms. Brink, I'm sorry, I didn't hear what you said.
I said Larry ignored me for 3 weeks.
Has he tried to get a hold of you and talk to you about this report from the Forensic Psychiatry Center?
I tried to get a hold of him 4 times and 3 times before that via email. And this is really all about just like some stupid shit that got blown way out of proportion. I've been in jail 90 days on a 30-day charge, Your Honor.
Well, the report from this Forensic Center, and actually it's not a 30-day charge. You're on a assault of a police officer charge and a habitual offender.
No, I'm on an RNO and a trespassing, and the original charge is a 30-day charge. And this is all about Meekoff Tire, to be perfectly honest with you.
Okay, Ms. Brink, are you aware of what the Forensic Center recommends? That they find you not competent now, but that they think
Well,
that you
I'd
can
like to
be
contest that because I am competent. And I don't feel like I had a fair evaluation, to be perfectly honest with you, and that Larry's not doing his job.
Ms. Brink, the question was, are you aware of what the Forensic Center said? That
No,
they
I am
think
not. He didn't say anything. Neither did
Then how do
she. She just kept
then
asking
how-
me history questions, and so I answered the questions, and when I realized she wasn't doing any serious evaluations as far as whether or not I'm competent, then I hung up because that's bullshit, just asking me about my history. When I got to gun talk, I was like, no, I'm not doing this with you because that's bullshit.
All right, and so they've sent me a document that goes through all of that and then goes through their analysis, their behavioral observations, their consultation with jail staff, their review of your records, and their
They didn't do
assessment.
any of that, Your Honor.
Mr. Brown, was she able to receive a copy of this?
I don't believe she received a copy, Your Honor. I did speak with her. I called the jail back on the 10th, 2 days ago. I did speak with her for a while. I did explain.
And that's
it
the
to her.
first time he's contacted me, Your Honor,
Ms.
since I came
Brink,
to jail.
stop. Ms. Brink, you don't get to interrupt when somebody else is talking.
What I'm
you'll
trying
have
to
time-
report to you is that he's being a
Mute
bad
her.
attorney.
Mute her. You'll be given an opportunity to talk when it's your turn, Ms. Brink, but you do not get to interrupt anybody else. Mr. Brown, go ahead, please.
Thank you, Your Honor. Again, back on the 10th, 2 days ago, I did contact the jail. I spoke with Ms. Brink. I did explain this to her. She is basically saying to the court right now what she said to me about not wanting to accept the findings. There were some comments made that prompted an officer to take the phone back. And that kind of ended the conversation. I did have a subsequent conversation with Mr. Fortier very briefly after that matter regarding the report as well. So she is aware of the findings. She obviously does not agree.
All right. Can we unmute Ms. Brink now, please? Now, do you have something that you wish to say, Ms. Brink?
I have lots to say, but not to you guys.
All right. Mr. Brown and Mr. Fortier, as to admission of the Forensic
Except that
Center.
I do want to contest the findings, like I've already stated.
Thank you. I'll give you an opportunity to do that in just a minute, Ms. Brink. Mr. Brown and Mr. Fortier, as to the admission of the admission of the Center for Forensic Psychiatry's report. Any objection to that being considered by the court?
No, Your Honor, no objection.
No, Your Honor.
All right. Ms. Brink, please tell me what your objection is to this report and why you think that you would be competent to stand trial.
because I am competent, number one. I have 2 children. That makes me automatically competent if I can keep track of my children and know that they're happy, healthy, and safe, and know what their names are and their age and where they go to school and et cetera, et cetera, et cetera, which I do and can. That makes me automatically competent, for 1. For 2, I know my history. For 3, I know exactly what this is about. And I've ignored my husband or husband to be, whatever you want to call him, for a long time, and he's pissed off.
Ms. Brink, do you know what the legal definition of competence is?
Being capable of talking, to be perfectly honest, that's the definition of competence, being capable of talking, which I am.
Well, it's a little more than that. Part of it is.
And it doesn't matter. I get a new hearing and a new evaluation because I'm contesting it.
That's not true.
That is true. That's the process.
All right. Do you believe that you are capable of rationally discussing the facts of your case with your attorney?
Not this attorney, but a different attorney, yes. I'd like to request that my husband call his attorney.
This is the only attorney that you've got.
Well, he's not doing his job properly, never has, and this is the 3rd competency evaluation I've done. All 3 I've passed, and you're lying.
All right. Anything else that you want to tell me, Ms. Brink?
I can't think of anything right now, but that doesn't mean that there's not anything else I want to tell you.
Thank you. All right, this court finds, based on the evaluation done at the Center for Forensic Psychiatry, that Ms. Brink is incompetent at present time because she's not able to rationally discuss the facts of her case with her attorney or critically evaluate decisions. Ms. Brink, this is my turn to talk, not yours. That she's not meaningfully able to engage with her attorney or maintain appropriate courtroom demeanor as indicated by her talking over others and not being appropriate in court today. It's also the opinion of the evaluator, and the court adopts that opinion, that there is a substantial probability that she can be restored to competency if she takes their medication and avails herself of other appropriate treatment programs. And that can be accomplished within the statutory time period for regaining competency. So the court will enter an order that the defendant is incompetent to stand trial, but is restorable, and that there is a substantial probability that she, if provided a proper course of treatment, will attain competence to stand trial within the time limit established by law. MDHHS is appointed as the medical supervisor of that treatment. Court orders the disclosure of necessary information to facilitate that treatment. And as a condition of release, the defendant will comply with all court-ordered treatment. And the court signs that order at this time.
Judge, just for clarification purposes, the evaluation and the opinion stated that in a hospital setting is where she could attain competence. So I guess my question is, or my request would be, that she remain in the custody of the county jail until a bed is made available at the forensic center, at which point she can be transported down there and medically supervised by the forensic center staff to be in that hospital setting. Specifically, kind of looking at MCL 330.2032 sub 3. That one is, the court may commit the defendant to the custody of the Department of Mental Health or to the custody of any other inpatient mental health facility if it agrees, only if that commitment is necessary for the effective administration of the course of treatment. Given the opinion by the evaluator in the evaluation, I would ask that the court find that be the case, and that she, again, remain in the custody of the county jail until a bed becomes available.
Mr. Brown, your thoughts?
Your Honor, she does have a bond. I would have no objection to that. I do believe that she can be restorable with proper treatment.
All All right, I've written on the finding an order of competency that the defendants to remain in the jail until released to the Center for Forensic Psychiatry / Community Mental Health for inpatient treatment. And I'll do that on an amended bond form as well. That's all for today, then. Thank you very much. And that will apply to both cases, pending cases.
From Plains to Prison, written by Chelsey Brink. One decision, although seemingly insignificant at the time, can affect a whole life, and in turn has the ability to affect multiple lives. You see, before prison, I was a highly respected member of my community. I became a registered nurse in 2011 and worked and volunteered as such until 2017. I owned a 2,500 square foot 5-bedroom house. I have 2 children who were taken away from me by their fathers, and like I said, one decision has the ability to completely derail a life. I've been incarcerated since 2018. I did 10 months in county jail before coming to Women's Huron Valley Correctional Facility. I came to WHV on October 15th, 2019. I was only supposed to be here for 6 months for a probation violation. 6 months has turned into a hellacious almost 18 months. I completed my required coursework in the first 6 months. It was required that I take healing trauma, phase 2 substance abuse, and beyond violence classes. I put forth effort in my classes and took it serious, thinking it could only help me and would facilitate a faster release from WHV custody back into the community. How wrong I was. These are weird times, I will admit. With the onset of COVID-19 pandemic, so much has changed. Beginning in March 2020, all prisoners have been required to wear face masks, which are suffocating. The prison has been shut down for a year now. It's only been in the last week that we've received new inmates. The school and all core programming have ceased to exist. On Monday, a couple of classes restarted. Prison is hell. There is no other way to describe this place. The food is nearly inedible. The healthcare and mental health care services are terrible to non-existent. Not to mention, I'm 12 months past my earliest release date. I've been given too many unfair tickets, and I've spent 113 days total on sanction. I've been disrespected on every level. It seems that certain individuals at the prison have forgotten who I am. I guess I can't expect them to remember me when I've forgotten who I am and when I didn't stay true to myself. I've settled in and I'm working hard to make my situation livable, pushing against the wildness while the wildness pushes back with everything it has. I remember when I was in county jail, I kept saying to others that the system is broken. But the thing I had forgotten along the way somewhere is that dying and killing are part of God's plan too. It's part of life. The question, though, is am I dying or killing? Is it possible to do both? And whose lives are affected by dying and killing? And how? There are times I could scream with the frustration of the uselessness of my own brain. But through the last 18 months, the thing I have found time and time again is that the human heart proves the most confounding mystery of all. I've learned to be patient with myself first, and have remembered to only believe half of what I hear and all of what I see. I sometimes think that being loved a little less than others can actually make a person rather than ruin them. Trouble is the only thing that seems to stick with me with any regularity, but I'm learning to think that can shape a person too. I've never known how to handle money. I'm not sure I understand it. The love of money is the root of all kinds of evil. Some have strayed from their faith in their greediness and pierced themselves through with many sorrows. Just because you break the law doesn't mean you have intentionally crossed the line into evil. Sometimes the line creeps up on you, and before you know it, you're standing on the other side. It is rare that what is expected and what is right are the same set of footprints. There are always exceptions to the rules, and the same applies to the letter of the law. Since being incarcerated, I have remembered that what I don't say is probably more important than what I do say. I don't want anyone's sympathy or to be coddled. I don't want anyone's pity or platitudes. I just want my old life back. And that notion, the utterly gut-wrenching, soul-crushing feeling that your life has been stolen from you, is something that you cannot fathom unless you've been through it yourself. Every terrible thing that you've been through in your life up until that point pales in comparison or seems downright ridiculous. You don't even know where to begin. I know I didn't, but I'm trying to make my way back to who I was, and in the process, I'm learning who I am. But it's a difficult journey. I've had to remind myself time and time again that we are not our past, no matter how traumatic or life-changing it might have been. You don't have to be superhuman to survive the bad times, and you can't always be at your best. But even when things look their worst, you can still feel positive about the future. Being optimistic is simply a choice made possible by being creative and proactive. A happy ending begins with having faith in your own story and looking for ways to create joy for yourself and others. We are all our own journeys, hopes, and dreams clad in mortal wrapping paper. And no matter how lost, lonely, defeated, or damaged we feel, accepting the love of others and loving them in return, to whatever return we can, will help make us feel whole again. I find some solace when listening to music, and also enjoy the escape afforded when reading. When your body craves physical relief, you can only listen to so much music and read so many books. It's been so long since I was a child that I've forgotten that there are building blocks of love, and that at the very bottom is comfort. Choice is a part of what makes us human. Love isn't doing whatever the person you cared for expects of you. It's doing what they don't expect, going above and beyond what you've been asked. Nothing stands out so conspicuously or remains so firmly fixed in the memory as something which you have blundered. I've learned that sometimes it's necessary to reteach a thing its loveliness. There are times I almost think I'm not sure of what I absolutely know. Some lessons WHV and being incarcerated have taught me are to soak up all the wisdom around you. Make time to dream big dreams and find people who believe in them. Learn from the people who know how to roll on the road and be ready to lay down your own asphalt. Know how to seize upon your own moment. Keep your real friends close. Make your mother proud. Honor the place you came from. Do the work, then enjoy the ride. I have to choose between what hurts and what hurts worse. It is a rare soul who would stand against a crowd.